2019, I remember.
With a bunch of other people gone.
Yeah.
Those other programs was end of October, early November.
Hello.
Nice to see you. Looks like
Okay. So are we missing seats?
maybe so.
I'm here. Regular people. Why the regular people? Yeah.
Nine.
Well, there's
We
a
have an unfilled seat, right?
Yes.
Okay.
But actual people,
People are here.
okay.
Great. Okay, I'd like to call this meeting of the TDLR, Speech Language Pathologist and Audiologist Advisory Board meeting to order. Roll call, I think, as Mary says, we have a full house. So Manny Bodner, Chevelle Bryant,
Here.
Tammy Camp,
here.
Kristen Culp, Kim Ringer,
Here.
Elizabeth Sterling,
Here.
Michelle Tejada,
Here.
and then we have one unfilled position for an SLP, is that right? Great. And so we have a quorum. And, since we do have at least one sort of new face, could we just do introductions, who you are and what your role on the board is, just to remind everybody who we all are? Can we start on that end?
So I'm Tammy Camp, and I'm a pediatrician and a public member.
I'm Michelle Tejada. I'm an audiologist.
I'm Chevelle Bryan. I'm a speech-language pathologist.
I'm Sherry Sensibrian, speech-language pathologist.
Kristen Culp, I'm an audiologist.
Kim Ringer, audiologist.
Elizabeth Sterling, and I'm a special ed director.
And just because I forget between meetings, just to remind everybody that if you do want to speak, make sure you identify yourself, because they have all the recordings and things going on. So identify yourself as you speak. The first item on the agenda is approval of the minutes from our meeting of June 30th. So everyone had a chance to take a look at those minutes.
Ms. Sensibrian, I'm listed as being both present and absent, and I was absent at the last meeting. This is Tammy Camp.
You're good, but you can't be both, right?
right.
Present and absent? Okay, so we can correct that. Are there any other corrections to the minutes of June 30th? I would entertain a motion to approve the minutes as amended.
Second.
Let Elizabeth move.
Second.
Kristen Cook second. There we go. All in favor?
Aye.
Motion carries, so those minutes will stand. The next item on our agenda is public comment. Did we have anyone wishing to make a public comment today?
Christine? I don't think we...
No public comment today? Okay. So then we're up to staff reports, and the first one is from the executive office.
Yes, ma'am. Madam Chair and board members, I'm Nick Volinas of TDLR, and here to bring you the executive office report, kind of a summary of what's been happening around the agency. First, though, I want to thank you all for being here, for coming to Austin, and for your service to the state. I'd also like to introduce to you Christine Reif, who some of you have met already, and she's one of our newest staff members and the primary contact for this board. Tamil Fletcher and Delia Luna are still here, but are working with other boards and are also here to help out as well. But Christine is your primary contact. We're glad to have her. She's got upwards of 28 years of state experience and comes to us from the podiatry board and has been here since early September. So please help us welcome her. We think you'll like her a lot. We do. On a very sad note, though, our agency recently lost one of its leaders as George Ferry passed away peacefully late last month on October 31st. George was our longtime compliance director since 1999. He fought a brave fight with cancer and came to the agency in '91. Great man, already missed, and our thoughts and prayers go out to his family. Our bill implementation period is still going on. We have, since state lawmakers have gone home, so to speak, after a busy 85th session and a special summer session, TDLR staff's been busy implementing legislation that passed during that time. All TDLR divisions have been involved in the process, which includes developing rules, communicating to stakeholders, appointing and prepping advisory boards, hiring additional staff, dealing with education, exams, IT programs, and more. So it's been some busy times. And as for new programs, to remind you, on May 29th, Governor Abbott signed HB 100, which immediately brought oversight of the state's transportation network companies to TDLR. On September 1, we picked up the state's podiatrist, and on November 1, we added 6 more of the health-related programs from the Department of State Health Services, phase 2 of the 13 total programs that were granted to us 2 years ago. So we now have code enforcement officers, laser hair removal, massage therapy, mold assessors and remediators, offender education programs, and sanitarians. Next September, we'll pick up the state's behavior analysts. Also want to mention that as we add programs granted to us by the legislature, lawmakers have also deregulated 5 of our programs since 2003, and they will deregulate another 4 over the next 2 years. So that action was recommended after our strategic planning process, which includes public and private industry feedback. The legislature agreed that the licensing requirement for these programs were unnecessary and burdensome, and doing without them posed little or no risk to consumer protection. Also, over the last couple of months, the agency has been busy working hard to help our licensees and small businesses in the Gulf Coast area recover from the devastation of Hurricane Harvey. In coordination with the Governor's Office and their Rebuild Texas efforts, we've been implementing procedures to assist all eligible licensees in the affected areas to help them recover, return to work as quickly as possible by removing the burden of red tape. Our Harvey focus now is on the rebuild by protecting small businesses and consumers, avoid unlicensed activity, and ensuring that they receive quality work for their hard-earned dollars. Information on all this can be found on our website, tdlr.texas.gov, and on the Governor's Rebuild Texas site. In addition to our web presence, also wanted to remind you again, if you're into social media, to check us out on Facebook and Twitter to keep up with TDLR news and events. But wanted to go back to the website for a minute and share some recent web traffic numbers associated with this program. Over the last 10 months, since January 1, your website has had more than 250,000 page views, and that's an average of 828 page views a day. You're doing really well there. 66% of those visitors did so from a desktop computer, while 29% did so from a smartphone and 4% from a tablet. And the top reasons for visiting the site, number one, applications and forms. Number two, laws and rules, followed by exam and CE information, FAQs, and advisory board and meeting information. So with that I will close. Sir?
Question?
Yes, sir.
When you say your website, does that mean the TDLR website or the speech language?
The speech language pathologist website, or page on the TDLR site. Thank you.
The next report is from the Compliance Division.
May I ask a little question on the website?
Yes, sir.
On the website, the TDLR website, I could not find the physical address. Is it on there? I'm not just listening. Or is it there? There was another address.
Mr.
It wasn't on Clayton Lane.
Yes,
It's on there.
It was a PO box.
Mr. Boatner?
Yes.
Yes, and it's Manny Boatner for the record. It is on the website, and we will direct you to it. It's this address as well as the Colorado Street address is there. Yes, that's downtown. So, yes, we'll direct you to where we can find both of those on our website. Yes.
Good afternoon. I'm Katie Bryce from the Medical and Health Professions section of the Compliance Division. You have our Compliance Division report. I would like to highlight the public outreach that we've done. I was able to attend the National Council for State Boards of Examiners in Speech, Language Pathology, and Audiology in September. It was a great opportunity to learn from other state regulators across the country and to hear about the issues they're facing and trends they're seeing in these professions. I also attended the Texas Academy of Audiology conference in San Marcos and had a booth there with our licensing director. Under the Health Professions section update, we remain focused on maintaining and improving the operation of the 7 Phase 1 programs transferred from DSHS, including the Speech Language Pathology and Audiology program. We organized a standard of care work group meeting to review rules regarding supervision, which will be covered later in the meeting. I'd also like to mention that since this report was filed, I was able to present to about 50 undergraduate students in speech language pathology and audiology at the University of North Texas, just guiding them through the licensing process and where to find rules and regulations and how to navigate our website and all sorts of other information. So, do I have any questions?
Cyprian. So Katie, I think that's a great thing that you're visiting universities. Do you guys have sort of a strategic plan for that where maybe you'll be able to do 2 or 3 per year, or can you talk about that a little?
Last spring, I was able to visit, I believe, 6 different universities, 3 in the southern part of the state and 3 in the northern part. This year, I hope to get a bigger jump start on planning that and organizing that, because it is something that seems to be very well received. And so, yes, I am hoping to be able to visit some of the schools that I didn't visit last spring this year, or maybe some of the ones that I visited last year in addition to new ones, just depending on what the program needs are.
And Sherry, since Cyprian, again, just one more thing. I always have that university perspective. You know, one of the things that we did at one time that I don't think we have through TDLR is for the schools that you don't make it to, some kind of a presentation that could be shared with those students, a little educational piece about all the steps. While it's all on the website, you know, having it all in one place as a PowerPoint or something that could be shared with students would be a great project, maybe.
Thanks, Sherry. This is Katie Bryce, and I appreciate that recommendation. I think that's a great idea. Thank you.
Any other questions for Katie?
Okay.
Okay.
Thank
thanks,
you.
Katie. Thank you. Education and examination.
Good afternoon. I'm Fanny Pringle with Education Examination Division. I believe you have our report. As you see, we've reported the number of emails E&E has responded to, and the number of continuing education audits conducted in October is based on 10% of the licensed population up for renewal last month. I do have an update for the number of jurisprudence exams. As of today, it's 2,138 completed. Can I answer any questions for you? Okay.
Sherry Cyprian again. You know, as we make changes to the rules, is there a schedule for updating the jurisprudence exam that kind of goes in line with that?
Yes. As of November 1st of this year, the Phase 2 programs have transferred to TDLR successfully as well. And so now we have all the JP exams together. And what we have coming on our agenda this year is to, first of all, restructure the format of the exams. Our goal is to make sure that the exams, that the licensees have a clear understanding of the rules and regulations that govern their professions. And to that end, we want to restructure the format so that it's more engaging, more interactive, and a better learning experience overall. Once we complete the reformatting, then we'll be looking to you towards selecting work group members who can address the content of the exam. We'll be going by program, and we'll look into rule updates, and in general, if the focus of the exam is where it needs to be, if we need to add more content in one area, if anything's is more obsolete, no longer as valuable as other things, and we'll leave it up to the subject matter experts to make those kinds of decisions. So far, the only changes that we have made is just for consistency, just making sure deleting any rules that were, deleting any questions that pertain to rules that were no longer in place, and changing all the references to DSHS to TDLR.
Sherry Cyprian. So my concern was at one time some of the questions had to do with some of the things that we've definitely changed, so they're not even proper anymore, like the amount of supervision, or whether you had to have an exception, get permission for telepractice for supervision. There were specific questions about those, and I just know that we've changed the rules and we need to make sure those are no longer questions, I guess.
We'll take a look at those, and if you like, I can contact you and give you an update on what has been done.
Sure, yeah, that'd be great, thanks.
Okay, great.
Anybody else have a question for Fanny? Okay, thank you.
You're welcome.
Enforcement.
Good afternoon, Chair Sam Cibrian and board members. Some of our recent accomplishments and current projects. On August the 18th, the Commission adopted the penalty matrix for this program, and it was published on the agency website on September the 6th. That's the penalty matrix that recommends the fines for various violations. We've begun using members of your board as experts in some of our cases. I can't discuss that too much because I don't want to discuss open cases, but we want to thank you, and it's been very helpful. We really appreciate that. Some case highlights. There were 3 agreed orders. There have been 4 agreed orders since the last board meeting, 3 of them for improper billing and 1 for failing to keep records. I want to direct your attention specifically to the default order. It isn't very often that I get to tell people that a default order is particularly important, but in this case, on July 31st, we entered a default against Keith Condit based on the fact that he had failed to disclose that his license in Idaho had been revoked as subject of an agreed order there. The Idaho revocation was based on the fact that he had obtained the Idaho license using forged documents. So his license has been revoked. He won't be able to reapply for 2 years, and we also have a record of why his license was revoked. So, key statistics: there were 109 cases opened during fiscal year 2017, 64 resolved, 9 agreed orders. Assessed penalties, $9,600, and collected penalties, $7,300. That is a truly astronomically high percentage of collected penalties for a program. There are some programs where we might have only a couple of agreed orders, and of course they're going to have higher ones, but for a program with a significant number of licensees and a significant number of cases, that's a very high percentage of collection. So thank you all. So can I answer any questions?
Questions about enforcement?
This is Tammy Camp. How long does it take from the point a case is opened until you'll usually have closure?
It varies. It depends on how much, whether the case can be resolved. First of all, it depends on if there's anything to investigate, because intake will open a case. Imagine a big funnel, and at the top of the funnel, the widest point is our intake section. They get all the complaints in. Some of those they will close because we can't get supporting documents, we can't get any contact with either of the parties, or because it clearly states a violation that we don't have jurisdiction over. I mean, they allege a violation by a profession that we don't regulate would be a common reason for closing that. If they find that they think there is a violation and it merits investigation, then the case goes to an investigator. And the investigator contacts all the witnesses, collects as much evidence as possible about the facts of the case. And that's supposed to take, I can't give you any specific number of days that will always take, but it's not supposed to be all that long a time. Once they complete the investigation, it's assigned to, there are now 2 attorneys that work on this program, me and another one. And then I decide if the evidence collected is something on which we could allege a violation. This is where the deadlines get a little more specific. If I issue a notice of alleged violation, the respondent has 20 to 30 days. Usually we end up giving them 30 days to respond, to request a hearing or agree and do an agreed order. If they request a hearing, then there is a 30-day deadline from sending out the notice of hearing to when the hearing will be scheduled at SOA. And it's never going to be just 30 days. It's typically 90 days between the date that we request a hearing and the available hearing date. So 90 days to get to SOA plus, and during those 90 days, there would be discovery, contact with the other party. If it goes to hearing, then the hearings are usually a day, sometimes two. The ALJ has, once the record closes, which may or may not be on the specific date of the hearing, sometimes judges will leave the record open for a few days for additional documents if some critical witness couldn't appear. I mean, there's all sorts of reasons why that would happen, but the judge there will be a little bit of flexibility in the amount of time between the hearing date and then the date of the record is closed. And sometimes that's just to let the parties submit briefs. The ALJ has 60 days to issue what's called a proposal for decision from the date the record closes, unless they give notice at the end of the hearing and say it isn't going to happen in 60 days, and I have somewhere in excess of 1,000 hearings in my life, and I've never had one where the judge didn't say it's going to take me longer than 60 days to get this out. So it's possible, just I wouldn't bet the farm on that one. Once they issue a PFD, there is a period of time within which the person who loses can file exceptions and the person who wins at SOA can file responses. And that 20 days unless you ask for longer. If it's a complicated hearing, it's going to be more than 20 days. And then usually 10 days for replies. So there's exceptions, replies, that takes about a month, and then it'll be scheduled before the board. And that takes, that depends on when the board schedule is, and if the PFD comes out in time to get on the next board meeting. So if I send out a notice of alleged violation and it goes to SOA, it is an extremely speedy case that gets in front of the commission in 6 months. Usually that's about 8 to 9 months. We have we have targets, and I'm sorry, I should know what they are, but I don't know off the top of my head, within which we're supposed to get a certain percentage of our cases resolved. But there is some review of enforcement as to how long we take to get our cases done.
Mary Winston, if I can interrupt, sorry, but thank you, Karen. She's taken us through a complete case if there's an investigation, from intake to investigation, through the attorney review, through sending out. What you see on the report is all of these cases on the report were resolved with an order. Most agreed orders, and then we had the one default order. All of the agreed orders, it sounds like they paid, which again, some programs may take responsibility and agree that, yes, I violated this rule, statute of my profession. However, and they'll agree to pay. However, when it comes time to pay, we can't find them, or they don't pay, or it's just heck to collect. But so far in your program, if someone is found to have violated a rule, statutory, what have you, and they have agreed to pay, they do. Those take less time. So time also comes in when we have respondents who are not responsible for, or who are not responsive to us. So if we have to get out of the four walls of TDLR, well, we're into the administrative law system, and we have to wait on the courts to be available. December, as I recall, is not a great month. Somebody has to go on vacation sometime. And so we're kind of at the mercy of the court system at that time. And when we actually do get a PFD, proposal for decision for the commission to review, that also depends on when the commission is meeting. So that's where Karen has taken us for a full-out case, shall we say. But if there's a violation found, an investigation has been had and handed off to the two attorneys who are responsible for this caseload, they have successfully issued agreed orders, and your fellow professionals, for the most part, have been honest about paying them. That takes a lesser time.
And I will note that that 109 cases that we've opened in fiscal 2017, that includes the ones we got last year. And that is a resolution rate of just short of 2/3 for this program in a year. So we have been tooling along very, at least in my opinion, very successfully in this.
So Sherry Sansevering, so Karen, 109 cases, how does that sound? I mean, I have nothing to compare that to. How bad are we being?
I don't know that I would be able to, it would be hard to calculate that. There are a lot of factors that go into complaints. One is, how many licensees are there? Our biggest program is cosmetologists. We get tons of complaints on cosmetologists because they do a lot of business and have a lot of contact with consumers, and they're also inspected regularly. So that program both has complaints coming in from the outside, from consumers, and from the inside, from when we send our inspectors out and find out that someone is, for example, not cleaning their pedicure foot spas. We don't do inspections in this program. I mean, we're not going out and having somebody do a checklist of how a speech pathologist performs. All of our complaints are going to come from the outside. There are a lot of speech pathologists, so I wouldn't be able, and I don't know that it would even be accurate, I don't know that even saying that the number of complaints is good or bad is something that we can assess. I think it's safe to say that if you get that your program has an unusually high number of places where people can report. There's schools, there's Medicare, there's Medicaid, there's insurance companies. So there's a lot of stakeholders in this program. So that tends to make things more self-policing than a program with a tiny number of licensees and very little contact with the public. So I will say, though, that the high percentage of payment of agreed orders speaks well of you. So that's...
I was going to ask how you got that money. What do you do to...
We send them a letter and they send us a check back mostly.
That's great.
It's been, I mean, we'll occasionally have a phone call, so, but yes, that's that's an unusually high rate of collection. So thank you for that.
Good. And one more. Sorry. Well, I just wonder if you can do education about, are there trends? Are there things that licensees consist out of these people across audiology and speech?
I might be able to answer some more very narrow, specific questions, but I don't know that I would want to speculate on trends. That's
something we should develop education questions about, test questions about, or...
I wouldn't be able to answer a question like that, so.
And Mary Winston again, the longer we have the program, the more we can kind of establish trends.
Sure.
It's kind of early on, and 109 cases, is it you in Virginia?
Virginia and me.
Karen and
And these are
Virginia
all me.
They knocked that out. So if we have more time, I think we'll be able to kind of figure out some trends. Also, Mr. Bodner, I know you want to speak, and we got a message that we couldn't hear you because we have people at their desks working who are listening to the program, and they did IM and say we couldn't hear Mr. Bodner. So if you could speak up a little bit or pull that mic to you for your next comment.
See, I'm trying to be soft-spoken here. Thanks. Manny Bodner here. Trying to understand procedures, I guess. I have 2 or 3 questions as we're elaborating here. Here's the first one, not in no particular order. Are there repeat offenders? And what happens if the person is cited, is agreed order, they pay the fine, a year later they do it again? Is that
Depending on the violation, it depends a little bit on the violation, because if it's serious enough, then it's going to go to a revocation. But generally what happens is if someone has an agreed order, and subsequent to the date that that agreed order is signed, or a commission order, so key date is, you can do it a lot, but it's only a repeat if it happens after we've entered an order on it. So someone signs an agreed order, if Brian signs a penalty order today, and Mr. Recidivist decides to do the same thing in January, and we find out about it, then the January violation, assuming it's not truly appalling, that will be a higher fine. And then if it happens again, then we would probably proceed to revocation. So, and then then after their license is revoked, then it becomes a much more complicated issue and a much more serious one.
But probably don't have a history.
At this point, we don't have, I mean, and I had the best pun about you wanting to be soft-spoken in a speech-language pathology meeting, but I refrained from telling you that, so.
So you have a hearing. Is the hearing within the commission? Or does
No.
it go straight to an administrative?
The fact-finding hearing, the analogy to a jury trial in the court system, happens at the State Office of Administrative Hearings. SOA employs administrative law judges, which are experts in administrative law. Almost all of them are board certified in this particular field. And generally they're assigned from, there's a couple of different sources. There's general panel, which are the people who can do anything. And then there's some subspecialties within that. But generally they know a whole lot about the procedures of administrative law, and they will have some familiarity with the substantive law of the specific case. They do the trial. That's where the witnesses are presented. That's where the documents are presented. They review the evidence, and then they make findings. They rule on evidentiary objections. They rule on discovery disputes, and they find the facts. And that's what a proposal for decision is, where they say, witness A was more credible than witness B, therefore I'm going to accept witness A's testimony and base my decision on the facts asserted in witness A's testimony. And that part of it is, with very few exceptions, unreviewable. I mean, that's what's going to go to the commission. The commission can interpret the law, but mostly the facts are found at SOA. And the reason they're separated is so that it doesn't look like the body that imposes the penalty is also the body that employs the people that are seeking to impose the penalty. So,
So the hearing is held outside of the commission?
yes, and then the commission
And then the
reviews the
commission
proposal for decision.
Will either accept that decision?
Yes,
Or reject that decision?
yes.
And then once it's accepted, let's say it's accepted, well, then you ask for the penalty and you go through that, and if there's an appeal, you go
Yeah.
through that. And if they reject the decision, then that's where it ends? There's no more? Or can the court come
well,
back
there are two
and
ways.
say, hold on, wait a
Yeah.
minute, this is our decision?
There are two things that can happen. If the agency wins and the winning is recommending a penalty, then the respondent, that's the person that I sue, can file what's called a motion for rehearing. If the commission, and that's a prerequisite, you have to rule, the commission has to rule on the motion for rehearing, and the motion for rehearing is a review to see if there's any kind of procedural defects in the case up to that point. If the commission says yes, and it accepts the motion for rehearing, approves it, then we have another hearing. If they reject the motion for rehearing, then at that point, the respondent can appeal to the district court. And there is a trial at the district court to see, they don't really try the whole case over again, it's just to see if there's enough evidence to support the commission's decision. And then, based on that, there would be an appeal. Ultimately, it could end up all the way through the entire court system. Mostly, they don't, but they could. If the agency loses, if I ask for a penalty and the SOA judge says no, I don't think there's enough evidence, and then the commission says, yes, I agree with you, there's not enough evidence, then we don't appeal. The commission does not appeal, or the agency does not appeal the commission's decisions. So that would stop at that point.
Okay.
Is that correct,
Thank
Mary?
you.
Is that a pretty good summary? Anything that,
Yes.
Mary and Wendy, do you want to add anything?
We get into the wheels of justice and they turn as they turn. Just to give you raw numbers, because we haven't manipulated them to come up with like real data, but we have 7,500 licensees, 7,521 on 11/1 when we got that number. That will fluctuate. And we had 109 cases open. So those numbers aren't manipulated with different factors to say, oh, it's good, it's bad, but just raw numbers. You have over 7,500 colleagues, and there have been 109 cases opened since you've been here. Right, Karen?
Right. And we do need to emphasize that that 109 number includes all the cases that came over from DSHS that we opened as well. So that is going to be, I will go so far as to speculate that that's going to be about a high figure, that the agency, as we go forward and those cases drop off, that the number of open cases in this program will fall down.
I said thank you, but I said thank you prematurely. So I have another question. Manny Bodner again, and this was based on an earlier discussion on visiting the college campuses and speaking with students there. And I noticed, just in case highlights, the number of agreed orders for failing to, for billing patients for services not provided seems in this particular grouping a bit consistent. So when we go around to the college campuses, are we talking about penalties that we're seeing with this discussion? But don't do that. Don't do that. That's wrong. You can't do that, or you're going to be fined, or it's going to be wrong, or you're going to lose your license eventually. I'm not going to suggest what to tell the students, but I'm thinking this might be a worthwhile discussion. If it's not already taking place, it probably is. But if there is such a consistency in the kinds of fines that are truly, in my mind, it's serious. It really is. It doesn't cross the line of what we're reading in the headlines these days, which thankfully it doesn't. Yeah. But these are not right either. So just that comment. So thank you now. Thank you.
And I stand corrected, and then Ms. Sterling, I want you to speak. I said 7,521 from numbers I had, but I have numbers now that say there are 15,000 licensees, so 109 complaints, some of which came over from DSHS, and that's where we stand. And I don't want to be rude to Ms. Sterling, she's new, and we keep kind of stopping her. Ms. Sterling?
That's fine. Elizabeth Sterling. I had a question about the follow-up for the clients of the people that you are pursuing. What is the process for notifying clients that may be seen, and whether there be notification? Is that something that you do? Is that something that you require them to do?
We wouldn't do that routinely unless the client was a witness in the case. Then we wouldn't contact anybody that was not directly involved in the facts alleged in that particular case.
Okay. So I'm just looking at, like, for example, Keith Condict, who apparently was practicing without a valid license. So is there some notification to him or requirement of him to notify the clients that he tested and saw that it was without a license, or?
His license is revoked, and the revocation order is on the website in public.
Okay.
So.
Well, okay, here goes another one. Manny Bodner again. So you hear all the time where a license is revoked and a person can't practice what it is, yet we find out after a patient gets hurt, they're practicing anyway. Is there any follow-up in the field to see, well, maybe this person really is practicing? They say they're not, and I'm not picking on anybody, but just to follow up, if that's the extreme, I mean, that is the extreme.
If we would get any-
follow-up?
If we got any more complaints on him, we would certainly follow up that way. But we don't do inspections in this program. So unless we received a complaint, then we would have to wait until we got a complaint.
And
J-
Mr. Boatner, because this is complaint-driven, we don't do spot checks, so to speak. We don't have inspections. We became aware of this gentleman based on a complaint, and if we became aware of something else, we would follow up based on that complaint. But we don't have resources, and that's not the regulatory model to go out and just seek possible unlicensed activity. And this gentleman also, it was a default order.
Yes, and this gives me Mary, if you'll let me interrupt,
Yes.
this gives me an opportunity to explain for the new board members the third way that we end up resolving cases. There is closure for no violation, or fourth way technically. Then we proceed to an NOAV if we do find something. In that case, there are three possibilities. There is an agreed order. That's what you see when they call me and say, yes, I'll pay. There's going to SOA and getting an order that way. The third thing is if they don't respond to the letter, to the notice of alleged violation, they never contact me. That is what happened with Mr. Condit, and that becomes a default order. And we have a form that says, that adopts what is alleged in the notice of alleged violation as the finding of facts. It goes to Brian. It's reviewed by general counsel reviews it, says, yes, he didn't respond. Yes, you sent it to the right addresses. And at that point, we sign a default order. Default orders always come in at fairly high penalty, assessing fairly high penalties because they don't settle. And there's no negotiations involved. That default process is one of the reasons that that follow-up in cases like this would be difficult. Mr. Condit never responded to us. We sent him a letter, and he never did anything. So we defaulted his and revoked his license through the default process.
Well, I'm sorry to take up so much time, but, and again, I'm not making a recommendation here, just thinking out loud, quite candidly, that yes, we never have enough resources in doing everything we want to do. I understand that. We have a responsibility, I think, to protect people in Texas who have or seek the services of a speech pathologist or an audiologist for the safe practice of those fields. Now, I think the question we have to ask ourselves, and I don't know the right answer to this, is that should we be providing a follow-up? And to be sure, these people really are not practicing. If we reject a license, or revoke a license rather, then the folks are not in that practice. And maybe we can't do it here, and I know trying to work with other agencies, other law enforcement agencies, that may prove to be an impossibility. But it seems as though if in our quest to provide a safe environment for this practice or practices, then maybe it's a question we should ask. And maybe that we'll find the answer to be, no, we really can't do it. That's going to be too invasive. We believe in independence. We don't want government to be looking in on our every move. Maybe that's the right answer. But I do think the discussion ought to be had, and then if the answer is yes, we should do it, then we should proceed. Or if the answer is no, let's keep government out of this. There's no place for more government intervention. It's just thinking out loud, really. But
I might be able to help
thank you very much.
You're welcome. I might be able to help you with a little bit that, to the extent that these practices, that licensees in this program operate within a practice, like they're hired or referred, I think that most of the people who manage the practices or who manage the insurance, the process of reviewing someone to see if the insurance company will accept them those entities do check licensees and check to see that someone is licensed in Texas. And that information is easily available on our website. So that by itself, if you, Mr. Condit applied for a license in Texas and wanted to work at someone's practice, the managing partner at the practice would check his license, or they should, and in most cases they do, because assisting the unlicensed practice of these things is itself a very serious violation. So the self-interest of the licensees that operate is going to help keep this process working. That people who have a practice or who refer people to a practice should check to see that they're referring it to someone who has a license. And I think that's going to help as more than anything anything else that we could do.
Other questions for Karen? Thank you.
You're very welcome.
Leonard wants to talk about numbers. I have other stuff to talk about. Oh, good. Okay. So the licensing division.
Good afternoon, Leonard Rivas with the Licensing Division. So in your packet, I provided the licensing report to you, specifically the fourth quarter, which is June 1st through August 31st. And I provided the number of new licenses issued, renewals issued, and the total population for each license type. I'll be glad to answer any questions about the numbers, if you have any at this time. No?
The numbers just keep going up.
They do. So one thing that I wanted to bring to your attention is TDLR, the licensing division, recently went through a DPS FBI audit. And I don't know the findings of the audit. I don't know what the audit consists of, but how it's going to affect your profession and for others programs here at TDLR is that in the packet, in the application packet currently, we provide the information for the applicant to go and get the fingerprints. We, based on that audit, have to remove that information from the application packet. So the applicant has to apply to us first. Once they apply to us and we have their application and meet the requirements, then we will notify them, you have to go get your fingerprints done now. So what that means is, for those of you that work at universities or other institutions, is you may receive more complaints because our time frame for processing may increase, because we have to notify them once they submit their application, okay, you're eligible to have your fingerprints done at that time. So I just wanted to put that out there so you're aware of it in case you get complaints from students that the process is taking a little bit longer.
So this is Chevelle Bryant. So how are you notifying people that they need? Is it a phone call? Is it a email?
So
does that notification at that point then include the steps that they need to take?
Good question. So what we are going to do is, if you submit your application to us, you provide us with an email address, we will email you the information and say, here's your fingerprint information to go complete your fingerprints. If you don't provide us an email address, we have to send you an RFI, which is a request for information, and we will attach the documents to that RFI so you can then take that and have your fingerprints done. And this is not only affecting the speech program, there's 4 other programs here at TDLR that it will affect. We are updating the application. We are going to put an FAQ on our website so people are aware this is the new process. Now, if they already have the old application with the FBI information, they're more than welcome to go, have it done. But probably starting December 1st, this will be our new process. Do you have any questions about the fingerprint?
Kristen Culp. So if you're getting the application and You said it has to be approved or
Well,
accepted?
sorry, yeah, I shouldn't have said that. We have to receive an application, and then we will notify
So
you that
have
you're
it and
eligible.
it's in the system? and
Correct.
An auto-generated
Well,
email?
it won't be auto,
or-
we have to actually physically type the email address in there and attach the documents to the
Okay.
email.
I'm just wondering what the delay time could be for something like that, from what it was with it all in one packet.
You know, until we go through the process, we
Right.
won't actually know. Anything else about the fingerprints?
Elizabeth Sterling, I had a question
Sure.
about professionals that are working in the schools, because they also have to be fingerprinted. Do you know if the system that you're using is the same system that the schools can pull down from, or are they going to have to do it twice?
So they have to specifically have fingerprints done for the speech language pathology program.
Right, but they also have to have their fingerprints done in order to work in a school. So my question is, do you know if the system that it uploads to is the same system that schools can download from, or do they then have to do it twice? Because then that delays their start date to be able to, one, get their license, get fingerprinted, get approved, then go get their fingerprints
Right.
again to go work in the school, which also causes a delay.
Yes, I don't know if that's the same system, because that's a different
Okay.
area that handles the fingerprints. Do
this
you,
is-
Wendy?
And yeah,
This is, I'm sorry, go ahead.
No, I was going to say, this Cheval Bryant, so as of right now, they are having to do it twice.
Right.
So, yeah.
Right, they have
Separate
a separate
systems,
system,
they
separate
can't pull
license,
from
less
the other.
separate purpose.
This is Tammy Camp. That was something that when the fingerprinting went into place, we tried very hard to make it work to where you only had to do one, and there were lots of reasons why they could never make that happen.
Yeah.
So,
Any more questions about fingerprints?
Sure, Sabrine. So Leonard, just thinking about timing, TAA already had their meeting for this year, but Tisha will have one in the spring, so that'll be great for Katie
Yeah.
to have a little something to give people that if you're,
We will provide that information to
There'll be a
Katie,
lot
and
of
then
students
she can
there.
also add it to her slides when she visits the universities.
that'd be great. And maybe we could send something out to some of the key people at universities who do that training for our students. I mean, I know who they all are, and let them know to plan on that little
Right.
bit of extra time. I'm sure it won't be drastic. but-
Right.
But when you're looking for your first job, every few
Exactly.
days count.
I know,
so-
yeah. Anything else on fingerprints? Okay. Okay, so the other thing that I will start including in my licensing report is here at TDLR, we have an online system where speech pathologists can manage their supervisees. And when that online system went live in May through November 9th, we had 5,835 transactions on that online system. And I'll be including those numbers in your next report, licensing report. Do you have questions about the online?
No, Sherry, no, I don't have a question. It's a thank you. As one of those people
Yeah,
who's using that
because-
system.
yeah.
Thank you. It's so nice to be able to just check, be sure what's the date, when do I
Right.
need to check on my intern. And it's great to have it all electronic. And
It is, and it helps us in licensing as well, less paperwork, so.
Very smooth.
Right. So the final thing I have is we've added 3 new staff members to the licensing and medical health professions. Veronica Coronado, she comes from the podiatry board. Charo McCrane comes from the Department of State Health Services. And then Audrey Astron comes from the Department of Motor Vehicles. And they all started with us various times, September 1st, November 1st, and October. So that's all I have for you. Any more questions?
Yeah, it's just one
Sure.
question. Manny Bodner here. You were talking more about speech pathologists.
Correct.
Does that also apply to audiologists?
It does not.
So
So,
there are no fingerprints or?
oh, fingerprints. Fingerprints, yes, that's,
audiologists?
yes, sir.
But what, the general discussion was more focused on speech
Supervision,
pathologists.
right.
Supervision of, oh, thank you.
Did I answer your question?
Yes, sir.
Okay. Any more questions? Thank you.
Next on our agenda is an update from work groups. We had a standard of care work group that has some recommendations for changes to the rules, specifically the rules related to supervision of SLP assistants and interns and audiology assistants and interns. So, Wendy, are you our speaker?
Good afternoon. I'm Wendy Pella, Assistant General Counsel. Items F1 and G kind of relate together. We did have work group meetings regarding the supervision. I do want to thank the work group members who participated, along with our compliance division. It was a lot of work and it actually kind of grew from its original assignment. The original assignment was really focused on those telehealth supervision provisions that are currently in 111.50G and 111.90E relating to supervision of assistance. It kind of, part of that original assignment was to add definitions, because in that place we were talking about telehealth, we were saying how much you could use direct supervision, indirect supervision. So we realized we didn't have any definitions of those two terms. So originally I started out to try to do definitions with those sections. In doing that, adding definitions up front, you realize, okay, how is this going to affect the whole chapter? Let's see how these terms are being used. And in doing so, we realized that the terms are being used also in the intern provisions, not just the assistant provisions. But we also found that there was inconsistent supervision-related terminology used throughout the rule chapter, and those terms weren't defined. So the project kind of expanded to, let's look at supervision as a whole, as opposed to piecemeal with different sections. Let's get everything uniform to the extent we can. So that's where the work group started. As part of that effort as well, since we were in the supervision rules, the department staff had also recommended separating out those supervision provisions from those larger licensing rules, like the .40, the .50. You may recall when we first did these rules, started our very first meeting back in November 2015. We had huge licensing rules there, but we had left a gap between like .30 and .35, .40, .5, knowing that those rules were large, that we'd want to come back and separate out those rules to make them more distinct sections. And so we took the opportunity as well when we were dealing with the supervision to pull those supervision rules out and make them standalone sections as well. And so hopefully that'll make that a lot more user-friendly if you're trying to find what your supervision requirements are. They're not mixed in with your education requirements and things like that, or your diplomas, any internships. We're trying to separate that out. So that's kind of what the work group did. And so the result is now moving to item G, and this is kind of the work product that came from all of that work. Just before we kind of get into the specifics of these rules, just a couple things I want to note on the, just in terms of process. You've got the rules in front of you. We emailed those out, but you do have them, hard copies in front of you on the supervision rules. Our plan is to, because we want to just deal with the work group's work product and kind of give that special focus on supervision. But our plan is to not take any action today. I mean, we do want to make changes and fixes, but not vote to publish. We would like to take these rules and roll them into a bigger rule package that'll include the legislative changes that were made as a result of House Bill 4007 and some other licensing cleanup changes. I mean, this is the bulk of the changes, but I think there's a lot of overlapping sections, and so it would be easier to do it as one combined draft. So we would come back at your next meeting and have a full combined draft, having it annotated in terms of this is a House Bill 4007 change, this is a supervision change, this is a supervision and a House Bill 4007 change. So example, so that's what our plan is today. So this won't be your only look at these rules as well. I don't have any questions. And then just before we get into the specific rule section walking through, just kind of an overview, the big things we did in this rule change is we added definitions, as I said. We talked about direct and indirect supervision. We also tried to standardize the supervision terminology to make that consistent, make sure when we were referring, everyone was referring to the same thing but using different terminology, so we picked select terminology. We tried to clarify the telehealth provisions as they relate to supervision. This affects several sections, and that's kind of really, I think, the meat of a lot of these changes. We try to standardize provisions for speech language pathology and audiology where it is appropriate. Maybe you're submitting a particular form or a particular process. It's the same for both, so make sure we've set it out in a similar structure, use the same type of rule text, so we all know we're talking about the same thing. We did want to update the supervision responsibilities and ratios, and then, as I said, we separated really large rules into separate sections to deal with supervision and then practice and duties. So that's kind of the high level. I'll just kind of walk you through the rule. Please feel free to jump in and interrupt if you have questions along the way. As we stated out, excuse me, as I said on that very first page, this is the definitions. This is 111.2 definitions. You can see we've made some cleanup changes on definitions 6 and 7 on that very first page. Turning to page 2, this is where you kind of get into the meat of it, the direct supervision. And we separated direct supervision for assistants and direct supervision for interns. Right now, the definitions are similar, but we didn't know at some point there may be a reason for them to be different. So that's kind of how it's set out right now. Any questions on direct? One of the things we did want to say with
Wendy.
Yes.
Sherry Sensebrine, make a note on definition 15 that it actually conflicts with some wording we have later.
Okay.
So we'll need to come back and compare, but for direct supervision of interns, later in the document, we've specified that it is in-person direct, but this definition allows telehealth direct. I think it's going to be confusing, so.
Well, you may need to say it's in-person direct. And that's one of the things when we have the direct supervision, the last line on each of those can be performed either in person or via telepractice, telehealth. Later on when we get to the rules, when we want it to be a specific type of direct, like we want it to be in-person direct, that's where we've stated it. So direct, and this gets back to that telehealth, are you there, are you not there? If you're doing telehealth,
Right.
are you in person or not? So for direct, it's defined, because it's what the point is, it's real-time observation and guidance, and that can be through telehealth and through telecommunications technology. So it can be either in person or, like I said, by telehealth. And we do try and make those distinctions. So if we go through and say, no, that can't, this is a type of direct supervision that needs to be in person, we'll make sure we flag that. Okay.
May I ask a question before we get going too deep in this? Manny Bodner here again. When you're drafting these proposed rules, what is the input that you have from this board?
We had the standard of care work group that was appointed. That was
Okay, so
agenda
there's
item.
board input,
Yes.
and y'all have worked together
Right,
in
and-
drafting these rules for our consideration.
Right, and so now we're bringing it to the advisory board for the first time. We realize this is the first time you're all getting a chance. The work group's really been in the middle of it, so this is coming with the recommendation from the work group, bring it to the full advisory board. And that's how we kind of use our work groups. Those work groups can really kind of spend the time and get really into the nitty-gritty about those details.
Thank
So those are the definitions of direct. Any questions about those? Page 3, we've added in-person. And this is helpful, and this is when we're talking about being physically present. And we've made the note that telepractice is not considered in person. So we try to make that distinction. I know there's a lot of confusion in some of the provisions being on-site or in the location or near, and so we've kind of come to this, and that took a lot of work trying to get the definitions right. Come to that. So that's what the definition in person. We've got indirect supervision, and again, we separated for assistants and interns. Right now, these definitions are the same, but it gives flexibility for some reason that they need to be different, or if there's input from the advisory board that for some reason that needs to be different.
This is Elizabeth Starling.
Mhm.
This really is just an English wording, and I don't know if you're taking feedback on that.
Absolutely.
But the supervisor is performing monitoring activities or providing guidance. That performing and those INGs at the end,
Mhm.
if it could just be the supervisor performs
Mhm.
monitoring activities or provides guidance, which is in line with your number 15 that says is performed. it just reads better.
Absolutely, thank you. We're taking all types of suggestions, so
And
feel
then
free to
that-
jump in.
And that also goes with, because 24 and 25 read exactly the
Mhm.
same
We'll
in
make the
that.
same. So you want to be the supervisor performs monitoring activities.
Performs and provides versus the ings at the end.
Okay. So performs and provides monitoring activities and guidance, and performs more monitoring activities and provides guidance to the assistant. Okay, we'll make those same changes down 25.
If you've made your notes
Yes.
on that, let me just ask another question again. Generally speaking, I think this is more of a question to the speech pathologist, and if it applies to the audiologist on this board, in the practice of, with the tele-monitoring, or whatever the right word is, telepractice. That's over, that's a video, isn't it? In other words, there's a screen and a monitor, and you're not there physically, but you can see there's a camera.
Right.
And you can see what's going on, and the person can see you, and you can see the person. Is that right?
Yes.
We advocate that. Is that also correct? We believe that's the way to go. In other words, that's one option that we have at our disposal.
Absolutely.
Is that correct?
Right, and I think,
Okay.
yeah, we've explained.
And we
the trends.
support that? I just want to ask the question, I remember the discussion we had a few meetings ago, but I want to be sure that we still support that practice. The telepractice is still viable, and it's an effective means to serve our patients and our clients. Is that correct?
So, Sherry Sensibrian, Manny, I think we believe that, but we also have a whole section on telehealth, so we believe it with some caveats. Certain ways to be done, certain things that need to be considered. So that's the whole other set of rules that we're going to look at today. So while we believe that it can work, it's not just a wide open, do it any way you want to kind of thing. There's some pretty specific rules that need to be followed. So we've got that, I think. It'll be one of the things we'll look at today.
All right. Well, let me express the genesis of my comments. And I was in the hospital a few months ago for quite some time. And again, it's not speech pathology, but it's another reason. There was a portion of that, and this is for telemedicine, not the telepractice speech pathology. So it's two different disciplines here. But there was a procedure that was done on me, and the supervising physician was not present, although he was present on a screen. And he could see me and the people in the room, and I could see him, and the people in the room could see him on the screen. I will tell you, I felt very insecure with that as a patient. And I'm looking at it as a patient, and as my role as a public member, I'm looking at it as we serve the public. In that particular instance, that particular case, again, the cases are all different, and I understand all the nuances. I understand all the differences. But in that particular case, I felt that doctor, that physician, had no clue as to who I was, or he knew what they were doing. I'm pretty sure of that. But I will tell you, I had no faith in him. I had to have the faith in the nurses that were there, that were implementing the procedure. So I guess all I'm saying, and this is all from my personal experience, and maybe others have other experiences, I just would like this board to continue to question itself, not second guess, and not be insecure in our judgments, none of that, but continue to ask ourselves, are we doing it right? Are we serving the best interest of the public? I know of all the discussions that we had earlier, that you can't be in 100 places at once. And out in West Texas, it's not like Houston, Texas, where you can go somewhere in 30 minutes and still be in the same block. And in West Texas, you could go for somewhere in 30 minutes and not get very far. And I understand that too. The telepractice has a place, and I know that. I just want us to be aware. I think we are, but it's not the end all. It's not. I'm not so sure that's the right answer yet. I'm satisfied with our decision. I just want us just to keep thinking about just not only that, but about our entire scope as we practice. Thank you.
Sure, Sincerely. And one thing that will, I think, make you feel a little bit better is that we have in our rules specifically recognizing the client or patient's right to refuse to receive services that way, that they still can speak up. And that is, it's part of the provider's job to be aware of that person's comfort level with providing services that way. So,
The
it sounds like
patient
you
is
didn't.
aware of that?
Yes, and so that's part of what we've written in, is that the patient has that right. Doesn't sound like you were necessarily given the choice, but our patients we've written in have the right to refuse services in that mode. So I think that will help
Well, that's good to
address
know.
a little bit of your
Thank you.
concern.
Thank you. At the bottom of page 3, we've also added a definition of intern plan and agreement of supervision form. We found oftentimes this term was explained every time they used the term, and so put the definition up here, and then you just get to refer to the agreement in the form.
Wendy, sorry,
Yes.
Sherry Sincerely, that one's going to have to be changed because it's stated the same way as assistants, and they're just not the same as interns. Interns actually, as a supervisor and intern, you don't get to tell them which activities to perform. So that wording won't work. They're really independent, but with a supervisor. So you can't tell them that so they have to agree to perform only activities assigned by the supervisor. You don't assign their activities at all. They're almost independent.
Okay.
So we're going to have to
We'll revise that.
remove that.
Do you
that piece at
remove
least.
the definition? Is the intern plan agreement still appropriate? It's just the definition and the scope of what needs to be corrected?
Right, it just shouldn't match the assistant. They're just two
Okay.
different levels, skill levels, and you don't tell your intern which activities they can do. They can actually do every activity that I can do.
Okay. Well, lucky, we're coming back again, so we will make this fix, and unless you have specific language now, we can go back and work on that in the interim and come back with some revised language and bring that to your attention. Page 4, we've got supervised professional experience as relates to interns. There's a definition there. Also, new definition 35, supervisory responsibility statement. Again, instead of explaining it every time we use that term throughout, it's just defined. And then you'll see 29 removed under the direction of, this is again another variation of supervision without really providing the details that we needed. So, any questions on definitions? Okay. Moving on to page 5. This is 111.40, the intern speech language pathology. We've made changes to the title, and this is showing the scope, the change in what we're doing in the scope. We've removing the licensing requirements and then having this rule just be about the education and clinical work. Do you want to note, this is an example of a rule. We won't discuss it here, but where we've got some licensing cleanup that will show up next time. So there's some overlap in some of these, but this is kind of a good example. So we just really wanted to focus on the work groups revisions as it relates to supervision. So we didn't make any changes related to for subsections A through F. So if you go to page 7, here's our first example of what we mean when we separated out the existing provisions about internship, supervision, practice, and duty. So subsection G and then the following subsections in this current section have been moved to 111.41 and .42. So then we hop to page 10, unless any changes. So you see lots of strike through. So it's not quite as intimidating. You'll get to page 10, 111.41, and this is where we've put the internship and supervision requirements. And I want to point on this, all of these new sections and subsections, I've annotated the draft to show you where that section currently is, so you can kind of do a comparison. I've noted which sections we brought over, obviously the ones we haven't, but you can always flip back to the earlier pages to see if this is what we brought over, this is what the text was. So you can do that comparison there. Also, point 41 is a good example of kind of trying to standardize the provisions, like between point 41 with the interns in speech language pathology and then point 81, the interns in audiology, kind of the same flow, the same standard provisions, if it's appropriate, same word text, so it makes it a little more user-friendly. I do want to note in subsection A, we added this new rule, and it's not a new requirement about having it be a department-approved supervisor, and the supervisor has to be licensed, and the intern has to be licensed. It's just in one nice place. What this also does is when we put, like, we're talking about the licensed intern speech language pathology, it's intern. When it's the licensed speech language pathology who's been approved by the department, it just becomes supervisor. Makes it a lot easier when you're reading the following rules that every time you say supervisor, you don't have to say licensed speech language pathologist, department approved supervisor. You kind of get lost in what the requirement is. So I think this will make it a little bit easier to read those provisions. B is, again, with current provision stating that their supervisors assuming all responsibilities, they have to comply with the act, and then those supervisor requirements. We've got the intern plan agreement as well. One thing to note under C1, we're having that plan's submitted at initial application, and if there's any changes or any additions, what we have removed is submission at renewal. If there's not any changes, we don't need you to submit more paperwork if there hasn't been a change. So that's kind of that. Page 11, we're moving on to the internship requirements. Again, we've kind of just brought these over from the current requirements. And again, I think we'll have some cleanup on this.
Number 4 is
Yeah.
not appropriate because that's from the assistants, but
Number
number 4 on page 11.
D4?
111, oh, C4, sorry.
C4?
C4. It's identical to the assistants, but it's not appropriate for the intern. It just needs to go away.
Okay, so where we have new rule, that shouldn't actually be a new rule.
Should not be a rule, no.
It's only applicable to. Thank
Only
you for
applicable
pointing
to
that.
assistants, right.
And that's where it's a good example of we tried to do a comparison. Is this the type of thing that needs to be in the intern and not? And our work members were really helpful in saying, no, there's a reason why it's not. It's only in interns, not in assistants, or why it's applicable to speech language pathology, but not audiology.
Confusing.
So we try to line up to the extent we can, but only where it's appropriate. So thank you for noting that.
That brings up another, just a question. Danny Bodner here again. There is a group, but I have to assume that staff would handle this, that compares what the statute is, and that the rules that we're writing is a compliance with the statute. We don't have any unintended consequences by our rulemaking and our regulatory procedures that is not intended by the legislature.
Right. And
Is that correct?
That is correct.
Is ongoing review.
Right, and that's something we always do when we propose rules to make sure, is there a statutory basis for this? Sometimes there'll be a broad authority of the commission by rule shall set up the requirements for interns, and it's very broad authority. Sometimes it's very specific, so we're always mindful of that. If we're adding a rule or taking a rule, where's our statutory authority, and whether it be very specific or a broad authority. So, yeah, a lot of these supervision rules, I said for the most part, we did try to note where there is a new rule, but for the most part, these are just a reorganization of where you're seeing these. Do you want to note on that same page on 11, D4, we added a clarifying sentence. I guess there had been some confusion about the fact that there had been some professional experience less than 5 hours, but even though it's still less than 5, it still needs to be supervised. So that's that clarification sentence there.
This is Elizabeth Sterling.
Yes,
I had a question about interns for speech pathology. I know that for the LSSP, licensed school psychologists, when they are interns, they get permission to work within the schools under supervision, but then they take their licensure test after they've done their year of supervision. Do do interns in speech pathology take their licensure before they do their internship, or is it aligned with? And the reason I ask is because I know in schools, when you're doing speech and language evaluations, they have to be signed, they're presented in an ARD, that becomes a legal document. So I'm just asking whether, I know with an LSSP, the supervisor has to sign also that evaluation, saying that they had reviewed the evaluation and the treatment plan. So I'm just trying to figure
Very
out whether that
sensitive.
needs to be somewhere in here or not. or-
Speech pathology, it's different. So they are
Okay.
licensed as interns, and they actually have the freedom to choose what activities, to give tests, to do everything, except just the specific supervision that we have. So we have no requirement for counter signatures or anything other than just a broad overview of their work and the specific hours of supervision. So it is different than an LSSP.
Okay, just checking.
A little more lenient, I'd say, than LSSP, yeah.
Thank you. Any other changes on that? Page 12, again, if you look at what's under 6A and B, this is just an example of where we've gone back and cleaned up language, making it standard where before it was like direct observation, I think the language, so it's now in-person direct supervision. So examples like that. We still have the extension request, evaluations, changes, internship. We tried to put some little headings in here to make it maybe a little bit more user-friendly. You can see where we've moved these from. For the most part, we have moved these over. And this is the changes in the internship, again, is a kind of a provision that we've made sure those standardized, any changes of internship. Any questions on that section? Okay. Moving on to 111.42, this is the intern speech language pathology license. This is the practice and duties. This will be, it's not, the section is not as large on the intern side, but it makes a big difference, I think, when we get to the assistant license, because it really sets out what they can and can't do. Again, that new subsection A just clearly states what the supervision requirements are. They always have to, in any professional context, state their status as an intern, what the credentials are. Do you want to note at the bottom of page 13 that D, we've brought over if they've completed their internships, they have to apply. There's no longer a temporary license, and you'll see this in our cleanup. House Bill 4007 repealed that temporary certificate, so there's a slight change in that change. And then again, we've got, they can continue to practice for 30 days while we're processing, and again, we'll come back with some cleanup to make some standardization between the license types on terms of that. Any questions on the 42? Point 50, this is the assistant in speech language pathology license. Again, we've narrowed the scope to be education and clinical observation experience. We haven't made any changes on those first few pages. We jump to page 16, and it shows up on 4. It's actually 11150E4. If you look at the subsection C, here's another example of what we were talking about being in-person direct supervision. We've eliminated the 100% direct in-person because then it calls into question, is everything else something less than in-person direct? So,
Sherry Cyprian. Okay, this is one we'll have to work out, because the point of the 100% was that it's not the supervision ratio of a typical assistant where you're watching 2 hours a week, that for those first 25 hours, 100% of everything they do must be supervised. So maybe that's not coming through clearly.
okay.
So
maybe this
They're
needs-
not allowed to do any work unsupervised is what we're trying to convey there.
Okay.
So maybe that.
Maybe it's a wording thing,
is
that
just
the way we
not-
word it, that we're not using 100%.
If it's not clear to you, then
Right.
it's probably not going to be clear to somebody else. But that is the point, is that they're not allowed to do any unsupervised work at all for those 25 hours. And it's there and at the top of the next page too, Wendy. So both places we need some wording that conveys that meaning.
So everything has to be 0. Well, is there a question then with the another work where we're saying it has to be in-person direct supervision? Is that something that they wouldn't be there the whole time?
So the idea is that, yes, you would be sitting or standing right there beside them 100% of the time for the first 25 hours while they practice providing services. So in-person direct makes sense, but I'm afraid if there's not clarity that it is every minute, then that won't be understood.
Well, and then I guess my question is for then those that aren't, when we say in-person direct, I guess that leads to the, well, maybe I only have to be there 75% or not. That's why I'm trying to make sure that by having it be, and it may be just a way we word this, but having it use 100% direct in-person supervision, it makes any other reference to in-person direct supervision, is it 75, is it 20, that's what I'm saying.
It may have to be separate sentences
Okay.
to make it clear that 100% of those first 25 hours must be
Okay.
supervised direct, using in-person direct supervision. Maybe it has to be separated.
Okay.
Because you're right, the number in front of the rest of it then may lead people to question. what it
Question the
means.
other references where it's not 100%. That was where we were hanging up, is that,
Right. So maybe referring back to the 25 hours and that 100% of those 25 hours must be directly supervised.
okay. And they must be supervised with in-person direct supervision.
Right.
And so it's just, I think maybe just a wording
I think it
thing.
would just be a simple wording change.
Wording thing, but it doesn't have unintended consequences on other times we've used that reference. Okay. So we will fix that and come back and you'll see that again. And we've got it down on, as you said, down on 6 as well. Subsection, when you turn to page 17, subsection F, again, F through the following of that section has been moved to point 51 and point 52, which jumps us to page 23. If there's any questions. Bottom of page 23 is 111.51, the assistant speech language pathology license. This is the supervision requirements. And again, you can see by the annotations where we've taken it, what sections and what provisions we've taken. Again, we have that same standard rule on subsection A about the supervision, about both the intern or both the assistant and the full licensee. We've got the supervisor still agreeing to assume all responsibility. We've got the supervisory responsibility statement form. And again, we've made some changes in this section about, again, when it's submitted. We're not having a renewal, but we also have tried to clarify some language about more than one speech language pathologist agrees. They can't practice without the SRS form. Note, like on 5 and 6, they're very similar, but they're from a different perspective. 5 addresses from the supervisor's point of view and what they need to do. If they see supervising the assistant, it's now supervisor, you have to do this. 6 is saying assistant, if it's the assistant supervisor sees this supervision, this is what the assistant must do. So it's from both perspectives. Did you have a question? Yeah. Okay. On page 25, the subsection E, this is a new rule, and this is direct supervision. We had this discussion at the work group. The direct supervision may only occur at the work site in which the assistant is providing services to existing clients or while the assistant provides services to cases that have previously been delegated to the assistant. I guess there was concern in terms of supervisor maybe making short-term temporary assistance just on the day of having the assistant come over and it's, hey, just take these cases, but they're not maybe formally assigned or their normal caseload. So this is what that provision was trying to address. Does this wording work for you all in terms of trying to address that situation? Okay. That is the new rule. Then we have client contacts in F. Again, we've pulled that over from where it is. This is kind of where we spend most of our time. Right there in the middle on page 25, subsection G, this is the amount and type of supervision. This was a section that we had lots of discussion at our very first advisory board meeting back in November of 2015, and it continues to be an area for revision and refinement. I think that we have a lot of issues in here, and so trying to make sure we've addressed everything. You'll recall that from the very first meeting, we switched from being the supervision hours from being on a weekly basis to a monthly basis to allow more flexibility in doing that. As part of that first meeting as well, the concept of telehealth was raised during that meeting. So the telehealth issues were put in there as well, and trying to distinguish between direct and indirect. And this is kind of the source of what that work group originally started and then expanded. We've had some clarification on what's G1, trying to be very specific about what those 8 hours are for, or direct, and at least 2 of them have to be of those direct have to be in person. The other 2 direct can either be in person or telehealth. 2, then we say the remaining hours can be performed indirect. 3, this is a new provision. When we originally adopted the rules, we had received a comment about what happens if if somebody works less than a month. At the time we had left the rules as proposed, we had made any changes. We've received some feedback, probably compliance has heard more, but what do we do in those situations if fewer than 4 weeks are worked, and maybe it's because of graduation or other issues that there's a month that you're going to not have a full month to work. How do we calculate this without then slicing and dicing it? And how do you at some point you have to be more than this. You have to do this many hours, less than this, without trying to slice and dice the month too much. So we've proposed if fewer than 4 hours are worked in the calendar month, then 2 hours of supervision must be provided each week worked, including 1 hour direct supervision and 1 hour indirect.
So this is Chevelle Bryant. I do obviously see a need to add clarification for that. However, this only provides direction if we know in advance that the assistant is going to work fewer than 4 weeks in that month. So say, for example, I actually have a couple of situations like this now in HISD where, so we're in week 3? Is this 3 of November? And so if there was no direct supervision during week 1 at all, because the supervision was scheduled during week 3, and then during week 3, the assistant is out on some type of medical leave that was not expected, then we haven't provided any supervision during week 1 per what this says. So I think that there needs to be maybe some clarification around there in situations that are unexpected. Even, for example, weather, right? So Harvey, if we miss a whole week in the middle of the month, but we haven't provided any direct supervision during that first week or the second week, then what happens with that?
Okay. Do you have any suggested language or anything there where
well, I think that, in those situations, we still need to be able to defer back to the original rule, which says that we're allowed to do the 4 hours of direct supervision in one visit, or the 2 hours, and then the 2 hours of telehealth. So we need to, somehow there needs to be some type of allowance to defer back to the original board rule in situations that are unexpected.
This is Tammy Camp. So it seems to me that the way the rule is worded, though, that it would still allow that. You just have to extrapolate based on the weeks worked. I mean, if you ended up only working 2 weeks, then you could still do just that number of hours of supervision based on the says, because it says must be provided each week worked. So it's not saying that it's not changing that, right? Because it goes, because you still would have the 4th week where you could provide all of those hours in that 4th week, because it's not saying.
Right.
It's not defining what week you're doing it. It's just
Well, I think that each week worked, including 1 hour of direct and 1 hour of indirect, that's kind of specific to, and maybe I'm interpreting it wrong, but I know that if I am, others will. So it's saying that if the assistant works 3 weeks or 2 weeks or 1 week, during that 1 week or 2 week or 3 week time, they must have 1 hour of direct and 1 hour of indirect. That's the way I'm interpreting it.
But so Sherry, so maybe, does it make any difference if it must be provided for each work each week worked. So you could provide it in the third week for the entire month if you needed to. This kind of sounds like it has to be provided in the week.
In the week, that's what it says.
Mary Winston, and this just came from Stephen, actually. Would the word may instead of must, would that help, or would that cause another problem?
Maybe.
Yeah,
That give the
this is a new
wiggle
rule,
room.
so if we're, because this isn't in here now, so it's trying to address those situations, but now if it's swinging the other way and causing more problems.
I think we need it.
I do too, I agree.
It just needs to be.
May might do it.
Kristen Culp, what about may be provided for the week's worked?
Well, it's 2 hours per week, for each week that you work, so you can't do 2 hours for, yeah, you know what I mean? It's hard. We know what it's supposed to mean, but gosh.
Okay, well, I guess, yeah, because our intent was to still have some type of proportion that you were using less, but it didn't end up all being indirect, or, and there's still some, we can work on that.
Yeah, I just,
This is Tanny Camp. It seems like the rules, I mean, when I read this, I interpreted it based on that it was the number of weeks worked, that you were just having to do that. So it seems like it could just be stated with another word changed very
Okay.
easily. Because that's how I interpreted that, was not necessarily that you couldn't do it all in the fourth week. It's just,
so it's based on, so that.
it's based solely on the number of weeks you work. You're going to have
Yeah.
to do the basic supervision for those numbers of weeks worked.
Right, so I think that is the clarification that's needed. So it's the number of hours of supervision that needs to be provided should be based on the number of weeks worked. I think that clarifies it, versus it has to be provided in that week.
Right.
So each week, I think, is the part that is kind of throwing it off. So based on, I think, is the language that needs to be in there.
So something to change it to the total supervision for the month is
Based
should be
on.
proportionate to the week's work.
Absolutely, that fixes it.
How's that?
That works.
Okay. And so you're saying there is a need, though, to have this type of
Absolutely.
provision? Okay. Well, we will come back and work on the wording on that. So we'll point that out for our next meeting. Any other suggested wording on that 3? Moving to 4, this is the telehealth. Also, one thing you'll probably notice is this G used to be one big paragraph, and so we've separated out into separate thoughts, separate G1, 2, 3, so it's a little easier, more user-friendly. Under that 4, this is the provision where we added the telehealth. We were saying that it's allowed, maybe used up to 6 hours for supervision, and specified that it's 2 for direct and 4 for out. The provision currently has the same language, but it says without applying for exception back over in section 213. The problem is when you get to 213, it says you can't use telehealth unless you file an exception. So we've got conflicting provisions. I think what's now .41G is the true intent of the advisory board, what we're trying to do. The difference from the former board is that you could not do telehealth, you had to have an exception. TDLR was making sure you could do telehealth, you didn't need to file an exception. Fortunately, we've got a couple of provisions that didn't quite line up. So we're pulling out the without applying for the exception here. And we'll make a clarifying change when we get back to 213. And 5 is still, it's still up to the supervisor to determine whether the skill and experience of, what the assistant, what they can do to be in terms of services they can provide, and they can also require additional levels of hours of supervision. This is a minimum. Did want to note this section, and when we did the very first round of rules in that very first meeting, when we added the flexibility to be have the supervision be done on a monthly basis versus a weekly basis, and added the telehealth, the alternative supervision form provision came out of this section because we weren't going to do that. again, we've got a leftover over when we get to 213 that's talking about alternative supervision. So there's another place we need to clean that up. But I was seeing nodding heads that was the intent, that we weren't doing alternative supervision forms. So I want to point that here. So any other questions on this section? This is kind of where the meat of it. But we'll come back with some cleanup language on that G3. H is delegating the task of the supervisor, what they shall do. We've got a specific section on page 26 on the admission review and dismissal meetings. I've carried those over. Records used to be kind of separated in a couple, that showed up in a couple different subsections. We've now consolidated that to make it a little bit more user-friendly in terms of maintaining records. And then on top of page 27, we have supervision audits. That's still the same, carry that over. And again, we still held on to our L about the, notwithstanding these supervisions, the department's still going to try and establish this processes to make it easier in terms of how you submit those, either supervision forms or notifications. So, any other questions or comments on point 51? Right. Point 52 is the assistant speech language pathology license. This is the practice and duties section. I think this is going to be a change that's going to be helpful both for licensees and for the department and the public, people trying to find what they can and can't do. And I think this is where in the assistant provisions you see the biggest change. Again, we have the standard kind of language, subsection A that we've kind of put across the board on all of these. We've got the same provisions on B. C is important in terms of here's the duties that the supervisor may assign to an assistant if they've received appropriate training. I've carried those over, and that's a list of what they can do. And then when you get to D on page 28, here's the list of what they cannot do. And we carried that over. That first, what's D1, used to be stated in the opposite of that they can work on any cases except for those that aren't assigned. So now we've put it in the do not list and put that right up front. And we thought that was kind of an overarching issue or item or provision that needed to go up front, that the assistant cannot work with any cases that are not assigned to the supervisor's caseload. And again, we've carried that over in the same list of, we did making changes on what they can't do. E is talking about the assistant representing special education speech pathology at the admission review and dismissal meetings, and carry that over, the same provisions over. So any changes or comments, questions on that section? Okay.
This is Elizabeth Starling. I have one question. You have on C, you say duties that a supervisor may assign to an assistant who has received appropriate training, including the following: conduct or participate in speech, language, and or hearing screenings. But then you have on the next page, the assistant shall not conduct evaluations. So are you seeing screenings and evaluations as different? Okay.
You're saying yes?
Yes.
Okay.
Okay.
Is there any clarification or anything we need to add to that? No? Okay. Thank you for the question. On page 30, these are the requirements for the intern in audiology. And again, we've moved the internship requirements out and moved those to point 81 and 82. So then we jump all the way to page 32. And again, you've got the internship and supervision requirements. And this is, we've tried to use a very parallel structure that we used in point 41 regarding the interns for the speech language pathology license. Similar provisions, and again, these are each of these annotated where it's coming from and where we brought it from. I want to be on the lookout for that section that you caught earlier about the new rule. One thing that is a little different, I think, from 41 and 81 is in terms of, is there evaluation? Let me see. We had the discussion back on, for interns in speech language pathology, there is an extension request and there's evaluations. We had that kind of discussion, does that also apply for audiology? And the answer was no. So again, it was one of those, we lined up the provisions, do these apply? And for the most part, a lot of these provisions line up in terms of internship requirements, changes in internship, but those were two that didn't. So we tried to do a careful review of that to see we were being consistent where, to the extent that we could. And again, bottom page 33 starts the changes in internship and what they need to do. Any questions or comments or changes on those? 80.82 is the intern audiology practice and duties of interns. This is page 34. Again, that same standard language up in A about the supervision, the supervisor, and the intern. C says the intern may continue to practice while waiting for the processing. And this is, we saw something a little different earlier, so we're going to come back in the next proposal and get those consistent. So every time you keep looking, we find some issues like that. So any changes on that? Okay, page 35.90, assistant audiology license requirements. Again, this has been narrowed just to be education and training. This is a little different from the assistants, and this was discussed in our very first meeting back in November 2015 about there had been changes in the assistant requirements for audiology versus assistant in speech and pathology in terms of requirements. So these will be a little different, and these won't line up with this necessarily with the assistant provisions for speech language pathology. Here's an example. When you look at B3, this is where we just said supervisory responsibility, and we took out what was 3A, that's the definition. And then what was 3B now just becomes 4. So we're just trying to make it a little more user-friendly and not explain everything time we say to form. Again, when you get to that, almost the middle of the page at 36 is, again, subsection D on has been relocated. And which means we end up jumping to page 41. And get you to 111.91, the assistant audiology license supervision requirements. We again use the same structure with A and subsection A and B standard provisions across. C, you've got your supervisory responsibility statement form, and you can see the provisions that we've carried over and some cleanup we've made down when you see C 5 and 6 from each supervisor and the assistant's point of view. Again, you get to D, they can assign, a supervisor shall assign duties and provide appropriate supervision to the assistant, just a general statement. Page 43, we've got client contacts again. And then the other big section here, and this is again the kind of what started the work group on this is page 43, subsection F, the amount and type of supervision. And this is as it relates for audiology assistants. And the numbers are different here. They already had it built in terms of 10 hours per week or 40 hours per month, so they have that flexibility. This is an area where we made some changes, and we had kind of these discussions about the terminology that was used in the audiology provision was on-site supervision and then being at the location where the assistant is employed. And so there was discussion about on-site supervision. Well, that could be both direct or indirect. You could be somewhere in the building. You're not directly there, so it would be indirect supervision, but you could be on-site and doing telehealth, so it could be direct. So we kind of had these discussions of what did we think was meant here. If there seemed to be certain tasks that needed to be in-person direct, but a lot of this did not. And so what we've made some changes through here, and so we try to get rid of the on-site supervision and at the location. But if there's, especially for any audiologists, if we've made a mistake and there's a reason for a distinction, let us know. But again, it's set out in that same, F1, it's at least 1 hour per week or 4 hours per month must be direct. They have they have fewer number of direct supervision hours than indirect. The remaining hours is indirect. Again, I'm looking at that F3. We probably need to make that similar change that we made back on the speech language pathology in terms of fewer than 4 weeks being worked. We can make a similar change there. And what's special about with F4, this is, when we get to 92, that there, in our very first meeting, there was a discussion that were certain tasks that had to be in-person direct supervision. And so that's kind of what lays out where you need to have that type of supervision. But otherwise, that's in-person direct's not required. Again, with F5, this is where we got into the telehealth provisions. We eliminated that provision that that allowed them to do telehealth without filing an exception as required over back into in the telehealth section. So we'll get that cleaned up. And again, there's still that overlying. F6 is, you still have to consider the skill and experience of the assistant. Any questions or comments or change? Yes.
Elizabeth Sterling, I have one question about the supervisory responsibility statement form that has to be submitted. Is that something that has to be submitted annually if the supervisor remains the same year after year?
We had, if we changed this, that was just being, if we go back a page, go back to 42C1, we had changed this so it was just an initial application for a license. Any changes in the supervision or the supervisor or any additional supervision. But we weren't requiring them at renewal to file a new form if there hadn't been any changes.
Okay, I was just making sure I understood that. Okay.
Yeah.
Thank you.
Moving on to the top of 44, we've got, or starting at 43, we've got delegating clinical tasks. What's the new G3 under delegating tasks, kind of near the top? The supervisor shall. This we put in, this is a new rule similar to the speech language pathology assistant rule. I want to double check if that's appropriate and right. Okay. I just want to make sure we weren't carrying something over we didn't quite match. Again, we've got the records, and we've reorganized that, so the records are all together. We still have supervision audits, and then the new J is, again, we'll keep working on processes to how you report those supervision requirements. 92 on page 45, 11192, assistant audiology license practice and duties of assistants. Point out the new subsection C, the duties that the supervisor may assign to the assistant who's received appropriate training. Here's the list of what you can do. Again, we've eliminated the on-site references, and so under C1, 2, 3, and 4, we've highlighted that these are under in-person direct supervision, then these are the activities. So these are the ones that are direct. And again, we've kept the list of what they could do the same. And you get to page 46, subsection D, you still have the list of the activities and the duties that they can't perform. We didn't make any changes to those, just carried those forward. And again, on page 47, we've got E and F. Those are still the same. Brought those over in terms of indicating their status, and then the crossover and overlap in terms of hearing instrument fitters in that statute. Any other questions or comments or catches on that? Page 48, this is responsibilities of the licensing code of ethics. 111.154, this is the requirements, duties, and responsibilities of supervisors. We've added "and persons being supervised" because the very last provision in this section is addressing what the licensed intern or assistant shall do. So we've made sure that it was clear there that they've got requirements in this as well. This section we tried to make, is another one we tried to make parallel to the extent we could. Looking through the provisions, they talked about the supervisor of an intern, but they didn't talk about the supervisor and of an assistant. So we have a new subsection D is the supervisor, assistant in speech language pathology must be a licensed speech language pathologist who's approved by the department. It's kind of a restatement. It kind of shows up in a variety of ways. But we didn't want to just talk about supervisors of interns in this section without supervisors of assistants. So we've added a new D, and we've added under what was D, now the new E, the reference to an assistant as well. What is now the new E, and this is dealing with an intern in audiology, or a supervisor in intern in audiology or an assistant in audiology. They can be supervised by an audiologist. It's not based on whether they have a master's degree or a doctoral degree. That was kind of a change in terms of who could be licensed, what the licensing requirement and what the degree requirement was, and that was changed in the statute, but that doesn't affect the ability to supervise, so that was not. So what you see, the E1, the paragraphs 1 and 2, that's being pulled out. They just need to be a licensed audiologist who's approved by the department. So we're pulling that out. We've, again, pulled out kind of the department-approved supervisor. Again, that's defined, supervisor defined up in the statute to be somebody's approved, but we've also got that restated everywhere, so it makes it a little easier. What's under the new F? We just changed from scope of practice to practices and duties of the intern and assistant. The scope of practice brings more of a concept of like the full license, because really the interns and the assistants are to some degree working under the scope of the full licensee, and this also matches the terminology that's used for earlier, so folks know what we're talking about. We've turned to page 49, what was F, and now F4. We wanted to raise this issue about the supervision ratios, especially as it relates to audiology interns and assistants. At the very first meeting back in November 2015, there had been discussion. The previous board was also making some changes, going through rulemaking at that time as well. They were making some changes to pull out the exception, because at one point there was also an exception here that you could file for an exception to supervise more assistant interns. During our discussion, there's also thoughts that maybe we needed to reduce the ratio for audiology interns or assistants if the assistant had a high school diploma. Again, the changes for the licensing requirements had changed for the audiology assistants. It had gone from being a bachelor's degree to a high school degree, so they thought, I think the thought process was, well, maybe they shouldn't supervise as much. That, you know, the supervisor needs to be more hands-on and have fewer folks to supervise. I think we've received, and really from our compliance division staff, I kind of received feedback that maybe this ratio is too strict or too restrictive. The proposed change here that we have is just going back to being, can supervise no more than 4 audiology interns or assistants, no matter what their degree is. And this would return it back to the former board's ratio, because the DSHS board had not, they'd taken out the exception, but they hadn't changed the ratios. That was something that was done. So we bring that to your consideration as well. Part of the thought is if you even have 1 assistant, then it limits how many other assistants or interns can be supervised.
I think we'll get better compliance if we just have one standard, supervise no more than 4 bodies, no matter what. Trying to figure out, I have 1 high school assistant, so therefore I can only do
Right.
1.
Right, because as soon as you had somebody who's with only a high school degree, then you only could do 2 total, and it didn't matter if somebody else had a much higher degree.
Unless audiology feels like that really matters. Seems cleaner. Or to just say 4.
Okay. So are you fine, though, with having it, still having speech language pathology be separate than audiology, kind of like how it's set out here for A and for B, but it's still 4?
I guess it keeps it very specific that way, so
Okay.
it's clear.
I mean, is there a
They're not
concern that
stressed
you'd have 4 total, that it's a combination of audiology? I guess you'd have to have a dual license to be able to supervise that, but, okay. Well, that was our recommendation, is to return it, the current ratios. And then the other provisions in that section are just clean up, cross-references, no changes. To bottom of page 49, 111, 213, this is another section we need to clean up. And this relates back to those supervision of assistance back in 111, was currently 50G, proposed 51G. As you can see, the cross, when you turn to page 50, we've got a third of the way down, you can see a lot of the strike through. We still had the exception language in here and requesting exceptions. And when you look at, it's a little hard to read, what was C, and it's kind of crossed out, an exception to subsection B shall be requested by the speech language pathologist submitting the prescribed alternative supervision request form. So we kind of have 2 issues here. If we're not doing exceptions, but we're also referencing a form that we intended to get rid of. So I think we're just adding maybe some confusion of the carryover. So we're proposing to do that. So what's up in subsection B is kind of lining up with what's now in the new .51 about the hours. And we've clarified that it's direct supervision of a licensed intern speech language pathology may not be undertaken through telecommunications. And that's because, indirect can be telehealth, but because of the supervision there, the direct, in the early provisions when we said it had to be direct or indirect, we were clear that it had to be in person. So just to make sure that those match. Any questions on those changes? And then what's 111.216 we noticed in doing this is that we had a provision on the limitations on the use of telecommunication technology by speech language pathologists, which is .213, but we didn't have a similar or parallel provision for the audiologists. And so we had modeled this after what was 213 as applied to audiologists as well, and added the supervision requirements here as well. And again, under that new C, the direct supervision of licensed audiology may not be undertaken through telecommunications technology, and that's because their limited direct supervision hours isn't in person direct. So, any other questions or comments? All right. Well, we will be bringing this back, and we'll note those things that we've made changes to. We'll come back with a combined draft on that. Thank you for hanging in there with me. I know it's a lot to digest.
Questions for Wendy?
Any questions about the process or what we're coming back with? Okay. All right. Thank you. So we won't be asking for a vote today, but again, we'll come back with those and with a combined draft and ask for a vote on those.
Question, let me,
Oh.
Manny Bowden here. Where does this go now? Does this go for public commentary, or does it come back to this board and then for public comment? What is our procedure?
The process for this, we're going to hold these particular proposed rules. We wanted to bring it as a work product of the work group to kind of, and there's a lot to kind of digest, so it's a lot to take on. It's kind of simpler to work on that by itself. We're going to come back at your next meeting, and these changes will be rolled into a larger draft that's going to have some changes based on what the changes were made based on House Bill 4007. So there'll be some changes that we have to make because of the legislation. There's also a few licensing cleanup things we saw that weren't kind of necessarily within the scope of the standard care work group that they were working on with supervision, but in looking at the rules and making these changes, things that we have caught or things that we've noticed in the year that we've had the program in terms of making sure the rules reflect the practices and what we're doing. So we'll bring those changes back. So at that point, once we've had a full discussion, then we'll ask for a recommendation that the department propose the rules as you've all seen fit. So we're not ready for publication yet on these. Does that answer your question?
Yes,
Okay.
thank you.
So, Sherry Sensibrian, my only concern about that is we're getting a lot of questions out there about this less than a full month thing, and this is going to take a long time to get an answer out there to people, it sounds like. And I was hoping we were going to have an answer sooner. I didn't realize the plan was to wait until we had the whole package.
Well, if it makes you feel any better, we're proposing your next meeting to be like the first week of January.
So sooner rather than later.
Yeah. Yeah.
That's better than summer. So.
Yeah, Mary Winston, Wendy is so diligent, she sent an email with the proposed, which was the second day of January. So that week.
That week, you don't have to make it specific, but.
Hey, so quickly.
So there won't be a long gap in time. So, yeah, and that our proposal is once we have that, then we would turn around and publish everything. But it's because there's overlapping sections, we can't have multiple proposals running at the same time that open up the same rule sections. So all of these changes are important, so to the extent we can get them going at the same time. So that concludes subsection G. Any other questions?
So Wendy, do you have one more?
I do.
So how about this? It's been 2 hours since we started. How about we take a fast, 10 minutes, seriously, break?
That'd be great.
And be able to stretch and come back, get a drink of water and
That sounds
all
good.
that?
That sounds
So we
good.
can listen to the new piece with fresh heads.
Sounds good.
Sherry, Sherry, gavel us out so they'll turn off the audio.
two documents. Chapter 111, and it goes to, it's also 111.
So she just separated the supervision piece and just a different aspect of telehealth.
Various places possible. We've had several situations.
Well, we're not really on flight until 8 something. Tammy, what is it?
The internet goes down or something.
We're just gonna try to jump on it maybe. Whether it's morning or afternoon. Audible, but you're not visible.
That's not what.
I'm going to call the meeting of the Speech Language Pathologist and Audiologist Advisory Board back to order. And we are ready for item G on the agenda, and Wendy Pillow will give us a little more information about 216. Is that where we are? No.
This is Wendy Pell, Assistant General Counsel. This is item H. This is related to 111.212H. And this is related to the use of telehealth by speech language pathologists in requiring the in-person initial contact with clients. The materials you have in front of you is the full subchapter on telehealth. What we're talking about is just one subsection, but it's sometimes hard to see it. Just you only get that subsection without seeing all the provisions that are around. So we aren't proposing to make any other changes to that telehealth as it relates to this proposal. But we did want you to have some context and reference in terms of seeing definitions, seeing the provisions around it, seeing the other protections or provisions related to telehealth that are around those in-person initial contact provision. You may recall at our last meeting back in June, we had a discussion about the trends that we were seeing in telehealth and telepractice that's impacting speech language pathology and audiology services, and in particular, the in-service initial contact with clients. Telehealth is a very big issue, and there's lots of segments of that big issue in terms of things that folks are focusing on. But we were seeing a trend, and one of those things we were seeing was because the Texas Medical Board was having issues there. Senate Bill 1107 was passed, kind of changing their requirements. They had been sued in a case called Teledoc. They had also had an investigation open against them by the Federal Trade Commission relating to antitrust issues in terms of having this restriction about requiring in-person initial contact. And it's related to telemedicine, but we thought it was related to us. Senate Bill 1107, again, addressed telemedicine for the most part, but also had some issues about telehealth or telepractice in terms of making sure it's the same standard of care. In your materials that we had sent you, in the past we had sent you copies of that Senate Bill 1107, the bill analysis, news release from the Federal Trade Commission closing their investigation about the medical board due to the passage of Senate Bill 1107. And then we'd also sent you a comment letter that the Federal Trade Commission had sent to the Delaware Speech Language Pathology and Audiology and Hearing Fitters, their board, regarding some proposed rules they were doing with telehealth. They've gone through three rounds that I know of, versions of proposed rules, and the FTC had commented on their second version was encouraging them to, they liked the fact they were introducing telehealth and telepractice into their rules, but they were encouraging the board to go further in terms of not having blanket restrictions or blanket requirements about everybody has to have in-person initial contact. That comment letter had noted that there were 19 states in D.C. that had telepractice rules. Noted Texas is one of 3 that had this in-person initial contact requirement. So we were taking note of that. We included those same materials again this year. For this meeting, we also included materials showing kind of the Delaware proposed rules in the comments. I mean, their rules, we do what we're going to do in Texas, what they're doing in Delaware. But I thought it was helpful in terms of providing background in terms of where they started, kind of where they moved to, showing the public comments that they received on the issues and concerns people are having in terms of anti-competitive restrictions, restrictions on access to care. Even with the state as small as Delaware, they're having access issues and making sure people get good services. So I thought it was helpful in terms of Texas is not the only state that's looking at this. I thought there were some common concerns that may be addressed. Addition, since our last meeting, the Texas Medical Board had proposed rules related to telemedicine, trying to implement Senate Bill 1107. There's a press release that they've adopted. I haven't seen the adoption notice to see what comments they received on that and if they made any changes. But I think there's a lot of different entities, different efforts from regulatory perspective that we want to see as guidance and look to see how we can improve what we need to be looking at, making sure we're not adopting rules that could be seen as anti-competitive or prohibiting or preventing or restricting access to care and services as well. So like the medical board and some of the boards in other states, a little different structure. They're more a policy board with all made up of licensees for the most part. We have a different structure here. We've got a commission that doesn't have any interest in any of the, financial or business relationship or interest in any of the professions. And then we have advisory board. So we're a little different structure, but we also just want to be mindful of best practices and seeing where the industry's going and making sure we're doing the best with our rules and make sure we're not having any anti-competitive barriers. or any restrictions to access to services. So we included that material in your resource materials as well, just as background to kind of prep you for this conversation that we're going to have. The draft that's in front of you, like I said, it's 5 pages, but it's only really one subsection. It's 111.212H. And this is in the section that's related to speech-language pathologist. It's not in the audiologist provision. There is a in-person initial contact provision in the joint rules with the hearing instrument fitters and dispensers. There's a separate work group to decide to look at those issues. They haven't met, but there isn't a similar provision in the audiologist rules related to their other activities other than hearing instrument fitters. So if you turn to page 3, and at our last meeting we had this discussion and we said that staff would come back and bring you some draft language to look at and some options. And so we've drafted 2 options. It's on page 3. That first option just repeals the entire section, that entire subsection. And this kind of conforms with kind of the Texas Medical Board proposed rules. They took out that section about their in-person initial contact. It kind of looks more like the Delaware proposed rules, the most recent version. And also mirrors the fact that the audiologists don't have a similar provision related to their duties that aren't hearing instrument fitter related. The second option, we've repealed and amended parts of it. Important to note that both of these options are eliminating the in-person initial contact blanket requirement that everybody has to have initial in-person contact with all clients. Both of these options eliminate that, but we've made slight variations. Option 2, we're saying that the initial contact between the speech-language pathologists and clients either may be at the same physical location or it can be through telehealth as determined appropriate by the licensed speech-language pathologist. And this language, it kind of reflects the narrative that was in the Federal Trade Commission comment letter to the Delaware Board. They didn't say you must use this language, but they commented that there shouldn't be maybe a blanket restriction, but maybe defer to the practitioner and the best way to do that. So this is a little softer in terms of letting the practitioner make that determination. But I think they both have the same effect of eliminating that blanket requirement. So we can bring 2 options for you all to open it up to discuss.
This is Tammy Camp. I like actually option 2, and for a couple of reasons. One, I think it still ensures that people are thinking, and it keeps them in the forefront in their mind that we need to think about, is this person an appropriate candidate? But it also frequently, as a provider of care, sometimes a rule helps me as a provider of care because a patient really wants something, but it's really not in their best interest. And if I have a rule or a reason to fall back onto that goes towards that, it makes it easier to help the patient understand why we should continue to do it that way. And so I like option 2.
This is Michelle Tejada. I also like option 2 just because it addresses telehealth, and I think by eliminating it, it just leads to more questions. And so this, I think, would answer a lot of questions.
I think if we don't address it at all, that's what Michelle said, they'll just be questions. So I think it's better to have it in there, and to also make it clear that it's a decision to be made by the licensed SLP, not by their boss who's not even licensed in the field or somebody like that. I think that's important. I do kind of hate to lose some of that wording about the things we're supposed to be looking at to determine if a person is actually a candidate for health to telehealth. But maybe, I mean, it doesn't really fit here now, but we might see if
that reminder that you're supposed to actually consider whether that individual in front of you is even a candidate.
This is Chevelle Bryant. I actually agree that option 2 is the better one. But could we add, like, in parentheses, these are the things to consider that a speech-language pathologist may consider when determining whether that face-to-face visit is necessary? And basically, what you said, put the language, some of that language back in there.
Are you saying put some of that language, but are you still having that still be an initial, requiring them to our concern is having them try to do this you have to still have that initial evaluation to make this, to determine whether they're a candidate versus having that.
So no, so just where it says, client may be at the same physical location or through telehealth, telepractice as determined appropriate by the licensed speech language pathologist, and maybe in parentheses,
Something like based on
yeah.
client's behavioral, physical, and cognitive abilities to participate.
Right.
So we still get to keep some of that good wording, because there are lots of folks who don't even know, how do you know if it's appropriate? At least remind them what they're supposed to be looking for. Anyone else have a feeling about it?
I have a question. This is Manny Bodner. Would you help me understand how are you going to determine a client is a candidate for telehealth if you're going to have the option of using telehealth, or telepractice as an option in determining that? So you're talking to a person through a screen. You've determined, well, this really isn't working.
Sure, Senator. The other piece is that, for the most part, if I'm going to receive a new patient, I'm going to get a fairly extensive case history. The child is a 2.5-year-old with autism, or the child is visually impaired, or other information that I should have up front that might help me. And I guess you could also consider that you could do one visit as a test visit to say this is not appropriate. So that would just sort of maybe confirm what you thought based on the case history. It's possible.
Not to belabor the point, I'm still going to ask the same question, because with all respect to everyone on this board, I am having difficulty knowing, even if you have a case report, you haven't seen the person yet. The person is a person. It's not a case. It's a person. It's a live person here. We're all sensitive to that. I know that. And I'm not alluding that any of us are not sensitive to that. But you have, I mean, I continue to struggle with telepractice anyway. I know it's there. I know it's important. I know it's an aspect of medicine and speech and everything, and I understand that, and I accept that. But in your initial evaluation, I continue to struggle to see how you're going to effectively make a determination without, as the chair just indicated, that initial visit. And so I, in my heart of hearts, I think the initial visit should be in person. I really believe that, but let me also say this, I'm here to be convinced I'm wrong. I mean, I'm trying to work my way through this discussion, and I'm really having a difficult time of it. So I am open to be persuaded, but so far I've not heard anything that would persuade me to say that telepractice, telehealth would be an acceptable initial visit?
I hear what you're saying. I think the FTC in their comment letter was noting, and I'm not a licensed speech pathologist or audiologist or a medical practitioner, in terms of what their thoughts was, is to put a blanket restriction down when there may be certain types of cases, certain conditions or certain, I would call it diagnosis, but in terms of the workup, that this would not necessarily, this person could go through telehealth. And the other thing is to remember is telehealth is not a substandard second-class type of service. There's provisions put in here in these in the rules in terms of having it that need to provide the same standard of care. You need to have equipment such that you can, be able to view the person, communicate with the person as well. So I think there's other protections put in there.
Mary
to sure that.
Winston, TDLR. Mr. Bodner, I don't know that we would convince you at all. I know what the FTC has put forth. I know the lawsuits that the Texas Medical Board has had against them. I know that this is the way that things are right now. The protection that we have here, if we want to call it that, it may be at the same. It's an allowance. It's not going to be okay for everyone. And I think all the practitioners on the board would probably agree that this may work sometimes, it may not work sometimes, and that's a professional call that they would make. But I definitely understand your concerns. It's just not the historical norm that you're used to, that any of us are used to.
This is Chevelle Bryant. Just for the record, I have to say that I agree with you, Mr. Bodner, and I think I expressed that in our meeting in June, but based on the lawsuits and the case law, I recognize that this is not one that we're going to win. So I think option 2 is a good compromise.
This is Tammy Camp. Personally, I don't prefer telepractice. I don't do it. But having said that, when you look in the literature, there are some good examples in the literature that state and show that there are equivalencies in care with some of these children. And those things have been coming out over the last, when we first embarked on this, there wasn't a lot of literature out there to be able to provide that comparison. But it has come out more and more, and there are some aspects that maybe even there are some kids that might do better with that type of care. And so I think leaving it in that position where you have that may is a good compromise. And, there are some places there are some locations where if you're really talking about a child who has a simple articulation error, that could very easily be assessed via telehealth and could probably be fixed very quickly when that child might not get services otherwise. And so I think that by putting this provision in there and not having that initial in-person contact as a must, it leaves you the freedom to have both options still there. And obviously, I think qualified practitioners who we say are licensed, they're not going to look at a kid who has been referred for a swallowing problem and think that that could be assessed over telehealth. That would be a very inappropriate use of telehealth, obviously. So I don't know.
This is Chevelle Bryant again. So I just did want to clarify that I do believe that telehealth in general is effective. It's an effective mode of providing services. I do believe that initial face-to-face, that initial evaluation should be face-to-face. So that's, I think, just to kind of clarify that. Telehealth in itself, I think, can be very effective. But I agree with you that initial evaluation, in my opinion, should be face-to-face. But I understand why we have to go a different way.
I mean, I think we
I
all,
suppose-
yeah, this is Timmy Camp, that's what, I think that's where we all probably
Right.
fall.
Right.
I suppose that's where my struggle is, because I'm not going to debate whether telehealth is effective or not. I already related my own personal experience with that. Y'all can have it. However, I do understand it is effective. It truly is. It can be effective. Not say it is, but let's say it can be. But I continue to struggle with the initial evaluation and the initial meeting. But could you bring me up to date, or this board up to date, and I may be the only one that does not understand the implications of the lawsuit, you said against the medical board, as well as in Delaware, where the board was found. Would you explain the reasoning where we have to have telehealth as an initial option, or the telecommunication as an initial option? What was the case that precipitated this judgment?
The Texas Medical Board was sued, a case called Teledoc, and they had sued the medical board because they had rules that required in-person initial contact for telemedicine rules. It's a very short version, not being someone involved in the case. The legislature this past session ended up passing Senate Bill 1107 to make those changes, to change their statute in terms of making those requirements, requiring that initial contact be in person, and that they have that blanket restriction. The Federal Trade Commission had opened its own investigation because of federal antitrust issues. There's federal antitrust laws. They had opened up an investigation against the medical board. Like I said, the medical board is structured differently from TDLR and the commission, our commission, I said, in the structure. So we don't necessarily have the same issues in terms of all the folks on the policy board making the decision are licensees, and so they're going to protect their interest, and they're going to make sure they kind of put in anti-competitive, kind of put in competition barriers in terms of anybody else being there. So we have a different structure. We don't necessarily have that. But our concerns are in terms of being an agency, kind of seeing kind of whether it would be the courts or with the Texas legislature or the Federal Trade Commission, what they're saying to others about provisions that we have something similar to, that it's kind of a heads up to us, hey, we'll take this as guidance. They're not talking directly to us yet, or at all, but we want to say this is kind of where telemedicine is going. Do we need to make sure that we've got rules in place that aren't putting in unnecessary barriers that aren't necessarily based in the science and the research, that everybody must do that. So that's.
So now, let me understand what the suit is. A doc brought the suit, is that correct?
That is correct.
Teledoc is a private for-profit corporation? Is that correct? Am I understanding that correctly?
That is my understanding, but I said I don't know all the details and ins and outs of that lawsuit against the medical board.
So, now all of a sudden it's clear. So this is what's going on. So just as has been indicated here, we're taking a preemptive rule. In other words, that we don't want to have to go and defend ourselves in this kind of a case if it should be brought against us. Am I understanding that also correctly?
Well, there's an element. I'm not saying that TDLR would get sued. I mean, like I said, we've got a little bit different structure.
But we're trying to prevent that from happening.
But we do want to be mindful of what's happening around us. We want to see, because we have rules in place, do we need to take a second look? It's not to say they can't be if there's a rational basis of why those are there. We have research to support that. It's just we're taking these as guidance around us to look at that.
And I think Mary Winston again, Mr. Boatner, and Wendy has really done an exhaustive study. Telehealth goes hand in hand with telemedicine. And what was thought about telemedicine previously is not necessarily the way it's thought of today. And in realizing and recognizing that telehealth is hand in hand with telemedicine, we are just with our rules, making them consistent across the state of Texas, where the telemedicine rules have gone, we're attempting to be consistent with telehealth, because our professionals work together with the MDs, with telemedicine, and so we're just going for consistency.
Okay, since I don't have a dog in this race, and since I'm going to, as we all are, and don't let me suggest anything else, we're here to serve the public interest. I have yet to be convinced on the initial practice, on the initial interview, on the initial, what is the word? The initial contact. I don't believe.
Can I interrupt this, Kristen Cole?
Sure.
I feel like for our purposes, we brought this up because there were instances of client care that were not being met because of distance from a caregiver and things that we wanted to have the opportunity to look at the case and decide if they were able to be assessed initially so that we could get care going and not put it off or stop it if someone could no longer come into the caregiver. So just for our purposes, I think that was a big thing we talked about it initially. I'm not a speech language pathologist, so it doesn't affect me daily, but I know other people have brought it up for some of those reasons, and so to me that's why this has to be an option.
No, I understand. I understand all of that. And I understand the need is greater than the supply. I understand that too. But I'm going to continue to advocate that I believe upon the initial contact, in person is the way to go. And if there are not enough people to service the need, well, that's a whole other discussion. But I understand the consistency in rulemaking. I understand the consistency in working with other agencies, and that too serves the public interest. So I understand that. I'm not surprised, but I continue to find it very interesting how these cases originate and how boards are now faced with this kind of a question. If this case was not, this lawsuit, in other words, did not happen, and the outcome did not happen the way it did, would we still be considering it? We may be, because of what Kristen just said. There are not enough people in the field. People are not being served. So maybe this is the best answer, maybe this is the best answer of all. But I continue to struggle with this, respecting everyone's opinion and feelings and thoughts, no question about it. But that's my struggle.
I think this is Tammy Camp. I think that this would have been brought because I can tell you I sat on the very first telehealth subcommittee that happened before this board even existed. And these were the things that we struggled with from the beginning. And so I think that it would have been that case, but I still think that this is a good option. And there are children that I know of who don't get services because they have to have that initial contact face-to-face. And so while we can say it does go both ways, and so, I would much prefer my child who has a simple problem to get a service via telehealth, and even for that initial evaluation to take place via telehealth, when I know that that can be done safely, because I'm the one who's ordering it, that they can do that and the child gets services versus not being able to get the service at all. And that actually is protection of the consumer.
Mary Winston, TDLR, this is a perfect example of why we have you all here.
Right.
And why we have public members and different practitioners, because we're talking about every edge of the spectrum from one side to another. And Wendy, who I love the way she drafts rules because she often gives option A and B. She's had a thorough thought process. to discuss either way. Sometimes she has A, B, C, or D. So I think this has been a great exercise because, as we know, it's not just the people here who are watching this. Actually, our executive office is watching it and did have one question for Wendy. Who won the game last night?
White game.
She can't.
Working on rules.
White game.
She has no idea out there in executive office land.
Right. Well, yeah, and I appreciate that, Mary, that we definitely need your input. And like I said, I'm not a licensed pathologist, not the licensed audiologist, I'm not a licensed medical profession, so we need to have that discussion. But it's also why we introduced it last meeting, saying, here's what we're seeing. And it's not, I mean, I make the case, but that's not the only thing. That's why we said we're seeing it in a variety of ways. That's one thing, but we saw with the FTC sending a letter to the Delaware board who was doing rules like us, nothing to do with Texas. So we throw that as an example, but we just say these are kind of the different ways, different methods, different venues that they're showing up in. And so we just want to be mindful that we're, and when you read some of the comments in the Delaware proposed rules, they got public comments, and there's concerns about having access to care, and maybe some of these, children could be treated on the first, all they need was initial contact, and it didn't have to be in person, that it could be solved right up front. But they had issues about, like I said, even in a state as small as Delaware compared to Texas, they were having access issues and as well. So I think it's coming from a broad perspective. I don't want to have the discussion be based just solely on just the Texas Medical Board litigation. I think it's much bigger than that, and I think it's shows up in a lot of different ways.
Elizabeth Starling, I've seen this with the ENT issue with trying to get students special education services, in that not being able to get an ENT to do the Part A or the otological, and then delaying the ability to then qualify a student for special ed services. And so now there's actually language that says that it can be a general practitioner in a short-term situation, and then until a student can be assessed. And so I see that being very comparable in the wanting to get a student assessed because you need the assessment in order to provide the service, and we know that there are students out there that need services. For me, I like the language of the behavioral, physical, and cognitive abilities to stay in there, and I think when you look at documentation and justifying our practices, having that in there and being able to say, that would not work for this student because they had behavior. That would not work because they had an intellectual disability and communication was not happening. So if later down the road we get into a situation where we're not using telehealth and someone is pushing us to do it, we can justify our decisions by being able to say, it did not work in these 5 cases of the 5 students that I'm serving because of this and this and this and this. And so maintaining that language in there for me really makes a lot of sense in being able to justify and categorize kids under those circumstances. And then, like you said, the straight articulation, or a student can't say S, T, or R, that is something that could be managed within we've had software programs for a long time where a student could get on the software and log in and just practice those things, and then those things are resolved fairly quickly. So anyway, that's just my 2 cents, is that I think that having that language in there and maintaining that really helps us down the road should we have to justify practices.
Sherry Sabrine, Wendy, am I correct in thinking this is part of just the package of rules? We're not voting today. This was just discussion.
We don't have to vote today. If you're needing more time, if we want to come back, this was not going to be rolled into the package of rules, just because of all the issues that this particular provision comes with. It comes with a lot more complicated issues than I think implementing House Bill 4007 and having the supervision issues that went through a work group to kind of vet those issues. We're going to keep this separate, and we can go back and look about the changes maybe we're suggesting, come back with the options. You don't have to take a vote today if you're not feeling it, or if you feel like we need to provide you with more information, or
I want to be as helpful as I can. Are you feeling, do you need what other states are doing, what other boards are doing?
So
I guess
this
I'm trying.
is Chevelle Bryant. So if we don't vote on this today, what is the time frame that we're looking at?
Well, we can come back at the next meeting. It'll
So
still be separate in
January.
January, and have it be separate, and you can look at this again if that's where the boards, it's up to you all what you're feeling. But it would be,
Kristen
it would be
Culp-
separate from the supervision and the
Are
other
we
things.
just proposing those changes that you just mentioned with those?
I think that was the only
Additional
change that
based
was
on
suggested
these.
was keeping some of that wording about the capacities.
That could be our next, once that's changed, then that is our next decision to vote or not.
I'm sorry, say that again.
We're changing those few last words that they would like to be kept in assessments.
Right, and we were still, there's a level review that we're still at as well, so we can take this back. I want to take back your suggestions as well on that issue in terms of some additional review. So even if we voted this is what you want, I can take this back and we can have some review, so we wouldn't have to actually propose to send them to the Texas Register for proposal yet. I think but you could get a good sense of where you are, what you.
Comfortable, get the wording finalized a little more, what we had in mind then, and vote on it at our next meeting.
If that's what you want. If you need to provide additional, like I'm drowning you in paper, but or resources, but if there's something you're feeling like this would be helpful to know, if, okay.
Okay.
So in understanding you're wanting it, it sounds like, not everyone, but kind of consensus right now for not option 1, but maybe looking at option 2 with the language being the initial contact between a licensed speech-language pathologist and client, maybe at the same physical location or through telehealth, telepractice as determined appropriate by the licensed speech-language pathologist based on the behavioral, physical, and cognitive abilities of the client, something like that.
I think something like that.
But it's that, okay, but the rest of that's not there.
Yeah.
Okay.
Just keeping that in there, saying that's how we should make those decisions, so.
But it is being clear that that's not, is that making determination whether you're going to use telehealth, or it's not a requirement that, it's not you're not making that determination before you get into telehealth? And you're saying no, okay.
Oh, I see what you mean. Considering, I do think that, as I was saying before, you sometimes know you're not even going to try to do an initial contact. I mean, again, it puts it back on the licensed SLP, but if I have a history that it's a 2.5-year-old with autism, non-speaking, with behavior problems, why would I even try? That seems like a waste of my time and theirs. So, I mean, you may have that information. It was originally in there to determine just their candidacy for telehealth in general.
Yeah, it was kind of like the predetermination that you had to have the initial to determine whether then future,
So this determination that we're talking about, I'm sorry, Chevelle Bryant, this determination that we're talking about would be based on records.
Yeah.
It would be based on records, the way it's,
So, Sharice and Cyprian, I think what I originally said was maybe it doesn't fit here anymore. I just hate
Okay.
to lose the wording entirely.
It may not fit.
It may not fit right there now, because the point is that you're supposed to look at things like whether the patient's comfortable with using this, but also do they have the cognitive, visual, and whatever abilities to participate in it. So I think the information was important, but maybe it doesn't fit there. So it would be worth looking at this a little more.
Okay.
And bringing it back.
Okay, we can do that, we can do that.
Elizabeth Sterling, you could say something like based on available records.
Yeah, for this piece, and then
You know,
save those words,
based
those other
on,
words for later.
right,
in the
when
document.
someone makes an initial referral for services, whatever record you have, you're going to make a determination about whether you think it might work or not as an initial.
Okay. Well, we can work on that language and bring that back again next time if that's what the board would like to do. Sure, feeling like you want to take action today. But again, it will be separate from the rest of these issues, because I think it brings up. Okay. Any other questions? And again, let me know if there's something else you feel like we need to provide you in terms of resources. Okay. All right, thank you.
Thank you. That was a lot of work.
Thank you. Thank you for hanging in with, I know it's a lot of work on your part as well, going through this.
So we are up to item I on the agenda, recommendations for agenda items for next board meeting. We have some things obviously we've talked about. Obviously, we'll be talking about rules. Other recommendations for something that we need to talk about at the next meeting? Anybody? Quiet.
This is Tammy Camp. I understand that there's going to be some things that are going to be done with ABA and rules that may be written according to that. Should that be something that should be at least on the agenda so that we can talk about that in case that there's overlap of scope, or even just making sure as a practitioner that it's clear what?
We, Mary Winston, TDLR, we did, we have recently become aware of that, and behavior analysts is, for everyone out here who doesn't know what we're talking about. I don't know if that is premature at this point. Maybe for the next meeting, if we could handle rules and revisiting this, and possibly having or appointing a work group at that time to go over those standards of care may be more helpful. Because if we jump into that, their rule packet hasn't, the behavior analysts hasn't even been reviewed. They've not met yet. So let's let them get their toes wet before we jump into that. And we do have a lot of work here to do. But I do see a work group coming for that. And maybe next time we can put that on the agenda moving forward. Yes.
I'm sure since they're sort of related to that topic, but others as well. What does TDLR see the agency's role as for consumer education? Because some of the things like Mr. Bodner, knowing that he would have the right to refuse telepractice if he were my patient, or understanding the difference between an ABA therapist and an SLP, or understanding the difference between an SLP and an assistant. A lot of that is the consumer needs to know, or that they can look up somebody online and find out if they are in trouble before they subscribe, go to them for services.
We try to make Mary Winston, the information available. If they're in trouble or have been in trouble, that information is available. We have poor Katie all over the state of Texas, which she does a fantastic job. That's typically at association meetings, professional meetings. We have done with the unfortunate hurricane situation with Harvey. We have been out in the different areas educating on not necessarily speech-language pathology, but our programs that have to do with building, electricians and ACR and things like that would affect people who've lost their homes. So we provided educational services there. I don't know that we have gone to our non-licensee body just as a general discussion avenue. I can't cross it out and say never, but that's something that I could discuss with compliance about maybe an avenue or a locale that would be good for that. I'm not sure, because some of this should be covered in patient information and when they sign different releases and, Mr. Boatner's situation in the hospital, I don't know. As you said, they have to approve it. The patient does in the situation of a speech-language pathologist. So that's a document that you sign. So further conversation, but I'm not aware of us going into just a general public avenue. I'm getting a shake of no. But we'll discuss it internally and we'll come back with some answers for you.
That's something that
Yeah.
TDLR does. Some state agencies do. Florida has a beautiful consumer education program. Because even before you select your provider, it helps for the consumer to know what should you be looking for. First of all, they should be licensed and the difference between the different levels. And the average consumer has no idea.
And we'll do FAQs, but it's on our website. But that is something that we can look at the Florida model and see what we can do. So,
Okay.
put it on the agenda, yeah, for a future meeting to discuss. And yes, maybe that will be another work group, more lively maybe than, or maybe not, than the other one. But, because I don't think anything prevents us from doing that, but pinpointing where we would go and who it would reach and that sort of thing, I think we can put that on the agenda for a work group to discuss. Yeah.
I have a question. This is Chevelle Bryant. So I did have one question about, back to the ABA issue. So you've said that their board rules have not been
Adopted.
They've not been adopted. Do you have any idea, is it soon? And I'm asking that because we have had a BCBA already telling parents in our area that they can provide these services. They can provide speech therapy services to some of our children. So, you know, I think that at least if we know kind of a timeline, because we're probably going to have to just be watchful and have a response ready for that.
I think Mary Winston, their first meeting is scheduled in December.
Okay.
And that initial meeting is bringing on rules that would just, was not even transferred, it didn't exist before. So that rule discussion, we would need a work group set up at that point to identify what they believe the law says and what the law says, or what certain people believe the law says, because that's very interesting.
Yes.
So thanks for, you know, the heads up. So we'll have an eye out for that. And our general counsel for that program is not in here. She's not the general counsel for this program. But December 13th is the first meeting, and I can tell you we won't be tackling that very difficult issue at that meeting. But because of the importance of that issue, we'll put it at the top of what we need to discuss. Yeah.
And I could see some value in some work groups across the boards, just like audiologists
Yes.
work with fitters and dispensers.
Yes.
So I think
I
that
don't
might
know
be
that
a
we had
future.
anticipated that, or I had not anticipated that, but from
Now you
earlier
know.
conversations,
Yeah.
I started thinking that way.
Yeah.
So that may
might
be
be
where
something
we
to plan
go.
for.
It may be where we go with this.
Other agenda items. Then I think the next item is to talk about getting together. Wendy would like to see us in January.
Madam Chair, we have two available dates the first week of January. One would be Tuesday, January 2nd, and then we also have Thursday, January 4th.
This is Tammy Camp. I think January 4th would be better, just from a travel standpoint, considering January 1st is New Year's.
A little time to recover from New Year's, so. So 1 o'clock on January 4th?
Got it. And then for the second meeting, we have the week of March 6th through 9th, and we have Tuesday through Friday, all available. Tuesday, March 6th, Wednesday, March 7th, Thursday, March 8th, or Friday, March 9th.
I'm sorry, could you repeat those dates for March?
March 6th, 7th, 8th, and 9th.
My first preference is Tuesday, the 6th, but really, any day we do it that week is just going to require some moving of things, so.
This is Tammy Camp. March 6th would be great as well, if that works for other people. Or the 8th. I have to be here on the 7th, so it certainly would cut down travel to do that on either the 6th or the 8th, so that we could do one flight.
Yeah.
The 8th would work.
And that's it, I could move, I could cover the
I
8th
could do the
either.
6th or the 8th.
If
Tuesday
we
or
had a
Thursday?
preference, I would prefer the 6th.
I think
7th
we,
and 8th.
the 6th, you got it.
6th at 1
Same time,
o'clock.
1 o'clock?
Uh-huh.
Tuesday, March 6th, 1 o'clock. Thank you.
We have completed the agenda, and I would entertain a motion to adjourn.
I'd like to have one comment before we adjourn. if I may. Much has been said, part of Mary here, the competence of staff. I know I may be in a minority with some of my opinions. I know I'm in a majority on this opinion. Staff has done phenomenal. And I know
Mr.
that we
Bodnar.
very much appreciate.
Speak loudly into the mic.
Yes, thank you, yes.
I know we're united in our appreciation and our admiration of staff and how we've been, just how everything is being handled. So congratulations and thank you very much.
We are so glad we got that microphone fixed. Thank you, thank you, thank you.
Thank you to staff, and welcome to Christine, and you'll get to know us all. So, okay, if I don't hear anything else, now we could entertain a motion to adjourn.
So moved.
Okay.
Second.
Somebody moved and somebody second.
Camp and Bryant, Camp and Bryant.
Gavel's out.
And so the meeting is adjourned at 3:20.